These three matters, they were supposed to be posted to today, but change of bench, they have not been listed. Here the pleadings are complete. The service emoluments of the petitioners, these three matters have been taken up today, have been retrospectively withdrawn for a period of 4 years, my lord.
We'll take it next week?
Yes, my lord. Any day next week as per my lord's convenience.
Pardon, Lordship. Two writ applications relating to the issuance of legal certificate and guidance certificate to the minor children. They lost their parents, Lordship.
Week after next week.
It was listed on Monday and Tuesday last week. This week, anyway, Lordship, the 6-month period for.
Don't waste time.
This is a transfer matter. All face admission transfer matter. Next tomorrow, my lord.
Tomorrow.
It's a case of
two matters.
It's a case of termination, my lords. This matter was specifically
Which year?
Of the year 2024, my lord. The matter was specifically fixed to today, my lords.
WPC 17722, the time was given to opposite party for 2 weeks, but they have failed to give the counter. So I would like to mention before your lordship.
File IA for restoration, my lord. Three cases, my lord, IA for restoration.
Day after.
May I seek my lordship to make a humble prayer?
We can make prayer, provided his prayer is over.
My lord.
Recall of order for restoration.
Yes, restoration. The next day.
When I repeated here 2024 regarding headmaster scale of pay, pending since 2024.
24, 3 weeks. Okay.
Pardon, my lord. The matter involves urgency in this matter, my lord. The guest lecturer who has been appointed since 2022, she is now going to be disengaged by substituting another guest lecturer. I have filed the writ petition on today itself. The settled law says that kindly take up it after launch, my lord.
No, not today.
The matter is so urgent, my lord. The another person will get appointment today itself, my lord.
When it was issued?
Friday, my lord. Friday.
It was
last Friday. Saturday and Sunday was holiday.
Holidays.
My lord.
End of the list or 2 o'clock.
My lord. Obliged. Greatly.
It is a pensionary benefit as well as the final pension, your lordship.
Which year?
So year of 2025.
25. 2 weeks. Okay.
Notice has already been issued in this case. Notice has already been issued in this case. Opposite party number.
Let us. Yeah.
Page number 1, item 1 to 13.
Serial number 5 में kindly be 2 accept.
5, 3 weeks at the request of.
Page number 2, 14 to 21.
Nobody. Nobody.
Page number 3, 22 to 25.
Doesn't matter. There is nobody, na? You have to see people also.
Page was 7, item 55.
55.
2 weeks left from. Actually 2 weeks time.
2, 3 weeks at the request.
I am for the opposite party. I'll next week, minutes.
Next week, very difficult. Otherwise, you would have taken that. We have already posted many minutes.
When the interim order is there, man.
Wherever interim order to continue.
Blessed.
Item number 1.
1.
The issue is whether in absence of any provision, a person, the departmental proceeding can be initiated after retirement. That is the
issue notice. Emergency notice. 3 days. AGA?
No, AGA is for government, my lord, AGA, and there is a board of secondary education, that notice will go.
Separate notice.
That, my lord, 2, 3 and 4 notice will go.
2, 3, 4. Emergency notice. AGA forward.
Item number 2.
Yes. My lord, the matter relating to rehabilitation appointments. While disposing a batch of cases, Honorable Appeals Court has directed to dispose of all of
Malayananda Sikhi.
Press matter. State of birth Jituluha.
But you mentioned in your prayer column. Kindly see.
After Malayananda Sikhi, recent judgment of Honorable.
One more judgment has come.
One more judgment, my lord.
Okay. Any representation given?
The right to dispose of all the pending cases before the Honorable High Court in accordance with the direction passed by the Supreme Court in the Jituloha versus State of Odisha.
Just looking to brother. Any representation given?
Depends, no representation given, applied. The petition applied as per the norm of the rule 1990.
They have applied.
My lord.
Where is that?
That is my annexure 4, my lord, page 15.
Annexure 4, page.
Page 15.
Compassionate appointment.
Compassionate appointment, my lord. Other of petitioner expired in the year 2014 and the petitioner applied within 1 year of his father's death.
Have you filed
No, the first time.
First time it has come. Issue emergent notice. Learned AG is requested to accept notice for which respondent? You have to lead the cast. You have to be little faster.
And then OP number 3, my lord.
Official code.
OP number 3.
OP number 3.
My lord.
All. Okay. 4 weeks. Yes.
Item number, my lord, 7 is same matter.
7 also same.
My lord.
Call along with it. Same order.
Next.
Yeah.
Item number 3.
My lord,
Yeah.
it's a matter for Ganashikha regulation, my lord.
Huh?
Ganashikha regulation. Ganashikha regulation.
Regularization.
My lord.
Which date you have posted?
In 2008, my lord. Annexure 1.
We have
Batch of cases posted to first week of September. The second
week of September. Issue emergent notice, EGF for the opponent, OPs. Call this matter along with the connected matters. Do you have number?
I have already a lordship order.
Number.
Lordship order. Already a lordship related.
This already happened.
No.
First time it has come, na?
No, my lord. This is first time, but earlier I have
That which that
I will give a number. I will give a number.
you give that
My lord.
call along with it.
Item 4.
Yeah.
Item 4.
RSCP matter. RSCP matter.
RTP, emergent notice, AGA for office. No private party.
No private party.
All right. Office.
1 to 3.
In the last week of, 3rd week of September.
No,
There was one connected matter, no? Before division bench.
no, this is something different.
Different.
This is the assured career program scheme. Next week.
Okay. Call next week and call this matter next week.
Yes,
All right. Call next week. Do you have any connected matter?
I'll give.
Just.
Item number.
Item number 5, my lord. I pray for a week's adjournment, my lord, in this.
All right. It is adjourned. Somebody asked for time.
Has been given.
Huh? 3 weeks given.
Yes.
3 weeks given. Okay. There is no res judicata for asking adjournment. You can ask also, no problem. Yes.
Item number 6.
6. What is this, brother? You that. So D, the package that compulsory retirement is ordered. Just look into.
It's a national, that is my national issue, not a state is not a party.
State not party, issue emergent notice. Okay. Wait. 3 days.
Item number 8.
Yes, brother. That you have to bring, something has fallen from your pocket. Kindly see that.
The petitioner was a retired person of peon of Utkal University, my lord, though they have regularized the service of the petitioner from the 2011.
Prospective regularization.
Yes,
Well, which date we have put other matters? We have,
Item 10 and 11 can be kindly taken up along with WPC number 331940 2024.
Squashing of impugned order 11/7/24.
My lord.
What is that order?
By virtue of that order, the case of the petitioner for
Go to Annexure 11.
my lord. My lord, by virtue of this order, the case of the petitioner for extending them the grade pay of rupees 4,600 has been
Equal for equal or principal.
No, only grade pay.
grade pay. Your
Grade
Lordship.
pay.
Yes.
So file is to grade pay of rupees 4,600, that has been rejected, Your Lordship.
But
Grade
And
pay
that is in-
4,600.
In terms of the
To some extent covered by judgment also.
there was an advertisement and it was specifically mentioned a certain scale of pay. With grade
4,006 scale of pay plus grade pay.
pay was
But
4,000.
scale of pay you have given.
Yes.
Why not grade pay?
The specifically it was mentioned in the advertisement that grade pay will be 4,200.
Not 4,600.
Not 600.
subsequently, the
After
executive committee-
they joined in the service, now they are claiming that you pay us 4,600.
That is on the basis of the decision of the executive committee, wherein the executive committee themselves had decided to extend the grade pay of 4,600 to the petitioners.
Where is that?
Executive committee decision is there, and they have also filed the counter supporting the case of the petitioner. Now question comes to the state is funding the
Let the institution go, not the government is your version.
yes government is funding, so government approval is necessary. So
The executive committee resolution is not approved in the government.
no, that the independent body that is registered under social system.
And similar matter, Your Lordship, the counter agenda is already in file, Your Lordship.
No, what is there now
Okay.
counter? Suppose if the
My lord.
executive committee passes a resolution,
My lord.
how can that bind the exchequer of the state?
Your Lordship, may kindly come to Annexure 9 at page 83,
83.
my lord. Because the decision of the executive committee is binding.
Binding whom? Government. Is it super government? It's a society.
My lord.
It's a society registered by the state government where contribution is in a particular ratio between state and the center, which I considered in another matter. How can the executive committee of a society bind the state government?
Your Lordship, may kindly see page 83, the last paragraph, Your Lordship.
83.
My lord.
Go to 83.
This is the only basis on which the petitioners are claiming the grade pay of rupees 46.
But government, they say they have passed the resolution.
Yes,
They have asked the government to consider approval.
yes.
You should have considered by now.
Considered and rejected by the
That
Annexure
itself
11.
is rejected by the order.
Yes, I will file a counter on this.
They filed the counter in this matter.
We have not filed. The society has filed.
Society has filed.
Yes.
But you don't want to file.
Yes, we will file.
You want to file?
Yes.
All right, I'll counter. 2 weeks finally, failing which right to file 1 stands forfeited. Regular patterns. Okay.
May I pray this matter may be listed along with
Along
double 33194 of 2024. My lord.
I come to a call of 3 weeks so that other matters also we can punch. To others they have given, to anybody else they have given.
No, my lord.
Not given. Just file objection. 3 weeks we have given.
Yes, sir.
May I please, Your Lordship?
Okay.
I mean, in this case, the petitioner has challenged the inaction of the opposite parties for not considering the case of the present petitioner with regard to the appointment under the Rehabilitation Assistance Scheme, in spite of the fact that the principal has already recommended the matter. And the earlier there was an order passed by this honorable that is under Annexure 5, on the basis of which that is at page 19, my lord.
Similar matters are covered. In terms of this, they have to consider representation.
Yes, my lord. Already under annex, they have considered, but the principal has already recommended the matter to the deputy director, but that is pending before the
Deputy director is not taking the decision.
Yes.
Who should take the decision?
deputy director, OP number 4.
For re-engagement.
Yes, my lord. For
Is it for re-engagement or engagement?
engagement under the Rehabilitation Assistance Scheme, my lord. And the principal letter is there at page 22, my lord.
The short grievance of the petitioner is as to non-consideration of his representation for engagement in terms of the recommendation made by the principal of
The principal of, that is OP number 2, my lord. Principal
OP
of,
number 2 institution. First off, learned counsel for the petitioner argues that the decision has to be taken by the
director, my lord. OP number 4, my lord.
OP number 4 director.
Higher secondary education.
Huh?
Higher secondary education, my lord.
Of higher secondary education. And that having not taken command, this court should intervene. First off, the copy of representation is at annexure.
The representation is there at annexure of 3, my lord.
Annexure 3, and recommendation is at annexure.
Annexure that is 6 series at page 12, at 22.
At 6 series.
Page 22.
Comma, to which he draws attention of the court. First off, learned ASC having entered appearance for the OPs on request of this court, although initially resisted the petition, now agrees to instruct his clients to look into the grievance of the petitioner as has been heard in the subject representations in the light of recommendation of the principal of the institution. Comma, time-bound way, provided that all contentions are kept open. First off, this is just and reasonable. First off, in the above circumstances, petition is disposed of. Period for compliance is 4 weeks. First off, which comma that would which would include conveying the result of consideration as well. All contentions are kept open. First off, if delay or default happens, comma, at the next level of the legal battle, if petitioner is driven to, comma, heavy costs may be imposed, personally recoverable from the authority who has to take the decision. Okay. It is open to solicit. Now, no costs. Replacement. Item 13. This is 12 is over now. Yes, over. Okay.
No, this is matter of annual increment to the Ganashika Mela.
Huh?
Annual income annual increment in the Ganashika
is not given to it.
Not given.
When the increment falls due in Orissa?
According to their
which rules?
According to Rule 77.
77 of
Orissa Service Code.
Please read.
They are entitled for that after qualifying OT80.
OT80 has to, it's a precondition.
Yes, precondition.
You have not done OT80.
My OT80. So that in situated persons.
We other day we said OT80 can be, it was a bit different fact matrix.
Yes, madam. I remember.
That you argued other day. That you have not, whether it is exempted.
Assumption that on the persons who are regular by secret allowed. That cannot be. Unless he is qualifies OT80, that cannot be. He cannot be.
So others it is given is no ground. To show to others it is given, it is lawful, and therefore I should be treated equally. If others it is wrongly given, Supreme Court said, for equality.
Wrongly. But
read the rule.
Rule 77.
Read what it requires.
The rule is applicable to the government servants. But I
not
remember, it is the schematic. After regulation, they are government servant. No.
You are not.
No. All government. After regulation, they are government servant. No. Primary teachers are government servant. No. Primary school teachers, they are not teachers. Then they have regularity.
For the
purpose.
What he said.
They are schematic.
For purpose of these rules, they are not teachers. Primary school teachers are teachers. Everybody was there. But the question is not that. For these rules, whether they fit into the definition of teachers in the question. Read the definition, teacher. That's what he's saying. You can't just smile, laugh like that. He is a very responsible counsel.
Madam King, then I have next minor kind of
2 weeks on that question. Item 14.
my lord. Here, my lord, petitioner is a ST 10 graduate teacher. Category of ST.
Yes, scheduled right.
Yes, my lord. And he has challenged the earlier circulation of 29/9/2024, where they have only taken the UR category and not giving the weightage to the ST and SC category. ST category, only 2 candidates out of 1,200 candidates, my lord, they have taken. But here,
what is the percentage of reservation?
Percentage of reservation that I have mentioned, that is for SC is 16 and it is for
Totally 27 it is.
yes, my lord.
Under that act.
Yes. My lord.
For ST, what is the percentage?
And your lordship, ST percentage is, my lord, your lordship will find 22.50.
22.5.
My lord. And is, sorry, ST percentage is, yes, 22.5 and SC is 16.25.
16.25, you should say.
Yes, my lord, 25. And your lordship will find the...
How many vacancies?
Vacancies, my lord, by then they have, my lord, enclosed an annexure 4 at page 32.
I am asking number.
My lord, number is more than, at present it would be around 2,000. But they have, yes, my lord.
You take notice, brother. Issue emergent notice. The DSC accepts notice for all respondents, all OPs.
All respondents.
Yes, my lord. They are the government.
All right.
All are government.
Call after 4 weeks. Okay.
My lord, may all these 4 matters.
Yes, my lord. Call.
And in earlier matter that they were directed to obtain instruction.
Yes.
Not all these matter may come along with this. Date may be fixed so that matter can be disposed of.
After 4 weeks, they will come. Wait, because they have to file. These 4 weeks, the period of 4 weeks is granted for filing the objections, if any. Filing which version of the petitioners may be taken with face value. Version of the petitions may be taken at face value. Or we'll just accept the petition and we'll pass the order. If you do not controvert them. Yes. Item 15.
Number 15, your lordship. Earlier I approached this honorable court for the purpose of counting of
Your case appears to be weak going by your voice.
Earlier I approached this honorable court for counting of seniority in the post of junior clerk with effect from 3/4/2012, your lordship.
24/12/24.
3/4/2012.
What is the 24/12/24? That's the order which is rejected now.
Your lordship, this honorable court directed to consider my reputation and the authority has already rejected my claim, your lordship.
AS is requested to accept notice. AS is requested to accept notice. Give copy to him. Next, item 16.
16 and 17 block grant pension. Your lordship, all these matter.
Issue notice. AS is requested to accept notice for the respondents. Call these matters along with
16,000, 2017.
2017. How can that happen?
1600 of 2017.
16,027.
Yes. 17 is same.
16, 17, same.
Yes, ma'am.
Okay. Just write down that number. Just write down and give that. Just give a small chip to brother. Yes. Item 18. 18.
And this is a matter of regulation of service. This petitioner working as workshop instructor in Department of Mechanical Engineering in the Engineering College since 2011.
2011.
His appointment on a running page 15 minor in contractual basis, but he has not been regularized.
Whether Jago comes to his aid. Jago comes to his aid. You are for one.
For one.
OP number one. ESC for number one. Emergent notice to other OPs. 3 days. Yes. Item 19.
May I please, Your Lordship? The husband of the petitioner, while working as an statistical assistant in the office of the Northern District Inspector of Schools, my lords, expired filing service.
Expired in a harness.
Expired in harness on 6/9/2004, my lord.
6/9/2004.
My lord. Thereafter,
what was your client's age?
My lords, now 41 years. At that time, she was 23 years old. Immediately after her marriage, when she was having a 4-year son, my lord, At that time, the husband of the petitioner expired. Thereafter, immediately she applied on the rehabilitation assistance rules, and thereafter, my lord, there are number of correspondence between the district education officer and the
That
district.
makes no difference.
My lord.
When did you apply within 1 year?
My lord, that is not disputed, my lord.
Show that. I am disputing. Show that.
My lord, your lordship may kindly see that has been forwarded by the. Your lordship may kindly come to page 15.
1-5.
My lords. The then District Inspector of Schools forwarded the application of the petitioner to the then Inspector of Schools via letter dated.
Yes,
My lords.
KV Vijayalakshmi.
K. Vijayalakshmi.
K. Vijayalakshmi.
My lords.
Widow.
Widow, my lord.
She had applied for?
Appointment under rehabilitation assistance scheme, my lord.
What was her age?
Her age at that time, my lord, was 24, my lord.
They are not considered.
Till date, they have not considered the last, my lord, the last communication, my lord, may kindly come to page 25, my lord.
35.
In 2013, my lord, the district inspector of school Chhatrapur communicated to the district education officer regarding what action has been taken on the application of the petitioner, and she also.
For 21 years, you don't consider. What should widow do? Government has no hard data. Government may not have a spouse, but officials in the government will have. Is it not? If the death happens in their family, what they will do? Issue emergent notice. ASC to obtain instructions. ASC appearing further as OPs to obtain instructions within 10 days. Call this matter immediately after 2 weeks. What kind of government? Widows, children, no hard data. You may reject it, my love. No decision being taken. That means no, we are above everybody. We are not answerable to citizens. Let citizens die. That attitude. Yes. Item 20.
May I please, Your Lordship? My Lord, it is second round litigation. And next to 8 is my rejection. Similar order, Lordship.
A is rejection.
Yes, ma'am.
Similar matters we have issued notice.
Yes, ma'am.
Issue emergent notice. ASC to appear for respondent of office. Call this matter along with the WP number so and so. Counter to be filed within 4 weeks. In which petition version will be taken, may be taken with the face value. Add that.
Short for a direction directing the opposite party number 2.
You can put off mic now.
Sir,
Yeah.
only short for a direction directing the opposite party number 2 to take a decision to change the ownership of the that housing plot, because initially the housing plot was also allotted in the name of the somebody, and he has also by way of an agreement that sold that housing plot in my favor. Let the accordingly that let them take opposite party number 2 take a decision.
Who is opposite party?
Sir, opposite party number 2 is the sir. Yes, Assistant Commissioner Housing, Raurkela Division, Basanti Colony.
This is a house site allotment.
Yes, housing colony.
You consider that?
My lord's housing board is different. We
Different.
don't represent them.
Okay, but we'll direct them to take a decision.
Sir.
We'll send that order copy through post. We have not. We don't. They need not be represented here. But please. The short grievance of the petitioner is as to non-consideration of his application for the grant of house site, despite making all compliances. First off, petitioner draws attention of the board to various documents that are produced as an excerpt in support of his claim. He or she,
He. Osoklika.
and some of these documents were as well. Prima facie. Next paragraph. Learned counsel appearing for the petitioner vehemently argues that where all compliances have been done, there is absolutely no reason to keep the application pending indefinitely, and therefore this court should intervene. First, Learned DGA accepts notice for first respondent, OP, and submits that the decision-making authorities or other OPs. Second OP.
Sir, second, OP number 2.
OP number 2. First off, Notice to OP number 2 is dispensed with since no positive order is being passed on merits at all. What is being passed is an order to pass an order on the subject application, which is kept pending indefinitely. First up, next indefinitely, right to speedy justice being one of the facets of Article 21 of the Constitution. First up, next up, in the above circumstances, petition is disposed of. Directing OP number 2 to consider subject represent application at
Annexure 2, sir. Annexure 2.
Application dated.
That is the agreement, sir.
In terms of agreement, consider application of the petitioner for allotment of the house site in terms of agreement dated 22 May 2002, that annexure A2 within a period of 8 weeks. First off, all contentions of the parties are kept open. First off, consideration to period of 8 weeks. Next paragraph. It is open to solicit. So and so. Okay. Now, one. If decision is not taken within 8 weeks, it is open to the petitioner to move an appropriate application for taking punitive action against respondent OP number 2, which may include heavy imposition of heavy costs in thousands of rupees personally payable by him. Okay.
Obligation.
This standard format you keep it so that we can avoid contempt matters also. Yes.
Item 22.
Registry to send a copy of this order to OP number 2 by speed post immediately for compliance. Okay.
Lordship, can you pass over? Item my lord.
Item 23. May I please, Your Lordship. Case relates to antedated regulation. Your Lordship, in an identical matter, issued notice. I'm giving the copy, Your Lordship.
You issued notice in that?
My Lord. That is Your Lordship.
Okay. To emergent notice, AG accepts notice for the OP numbers 3 and 4. 3 and 4. Emergent notice to 1 and issue emergent notice to 1 and 2. First of OP number each AG and request accepts notice for OP number 3 and 4. First of.
Your Lordship, 26 and 28 also say.
26, 28. Then call along with the WP 22011 of 2025 after 3 months. Okay. Item 24.
Item 22. Which one pass out?
22.
Yes.
Come, are you ready now?
Yes.
Come.
My lords, I'm waiting for the opposite parties, CBSE. The counter is ready and it is to be sold.
The counter?
My lords, it's to be sold to by the officer concerned.
2 weeks?
Yes, my lords.
Within 2 weeks, you will file the. You serve a copy also.
But this is a case where because of identical answer, the result has been cancelled.
Well, I have the objection counter.
The difficult
counter can we do?
No, my lord, I'm conscious of that. Lord, say, may keep this matter next week.
Next week, we have posted.
Yes. And along with other connected matters.
Along with WP numbers.
I will give.
I have some matters similar. May I give them? Yes, ma'am. The similar issues.
There are batch of cases.
And in my case, one of my case, pleadings have been completed. Along with the
Your friend wants to file. Generally, he will not take time. And very sincere friend.
Yes.
Yes.
The other list of identical cases also I'll provide.
Provide.
Yes.
You give a memo so that along with that, all they will.
Yes.
Some date may be fixed for this.
You also may fix.
Fix some date of the 2 weeks. Yes.
Item 24.
Petition is written
LS teacher,
Retired?
lower secondary school teacher, that PET. In 22, the government has issued a letter that those PETs, LSS, the lower division teachers have passed BD, their name may be sponsored to this department directed for their promotion to the junior secondary school teachers. Petitioner BD from the Bardhaman University, West Bengal.
When did he do that?
You also kindly see annexure.
I am asking.
13, my lord.
I am asking the question. When judge asks how many teeth we have, you need not open your mouth at all. I will not count. I will go by your number. I am asking the date now. When did you get that graduation?
22, my lord.
22.
August, my lord. I am in the meantime retired.
But when did you retire?
Retired, my lord, 2024, my lord.
24.
My lord.
After getting B.Ed.
B.Ed, my lord.
By that time, they should have given that benefit.
Promotion to the senior club. But
brother,
this court has directed, my lord. This court has already directed. I have annexed to
that.
Yes. Your lordship can
despite that they are not giving.
Your lordship kindly see page.
Let him take notice, brother.
My lord.
Again. Issue emergent notice. This is a second round litigation. First off, may be requested to accept notice for the respondents. First off. Only government.
Only government.
Call this matter in October 2nd week. To file objections, if any, filling which petition will be may be taken with face value. Okay. Any other matters are there? No.
25, my love, petitioner retired, and master my love, retired since January 2012, not getting pension, only getting provisional pension, and not getting final pension and retirement benefits due to pendency of the criminal proceeding.
Criminal case is still pending.
In the meantime, criminal petition has been acquitted, my love.
Acquitted.
Similar, my love.
No disciplinary proceedings were
no initiated, my love. Similar, it is cordial similar, annexure 5 pending. Annexure 5 is pending.
Annexure 5 representation.
I have made a grievance for the respondent.
No, brother.
Give orders, madam.
I will take your order, no problem. Suppose now, if an order is given to consider your representation, it will do the. But will they do all that?
My lord, annexure 4, page 47, they have a categorically stated, I have obtained on the RT Act, my lord, that it will be sorted out very shortly.
They have said that.
My lord.
Shortly means according to them, not English word shortly, their own dictionary. The short grievance of the petitioner is as to non-finalization of its terminal benefits of service, which include pension as well. First up, Learned Counsel for the petitioner submits that the delay in finalization of PPO, pension payment order, was due to pendency of a criminal case pending against his client in the court of JMFC Bhapur in GR number 69 of 2004. And that the said case having culminated into an order of acquittal on
26/12/2024.
26/12/2022. 24. Comma. Now there is no impediment for finalization. First up, he complains that despite his client's representation dated 2/4/2025, a copy whereof avails at Annexure 5, comma, no decision is yet taken, and that there is no hope of any decision being taken in the near future, going by the experience with the government of the kind. First up. Next paragraph. Learned AGA, on request accepting notice for the respondents, agrees to instruct his clients to look into the grievance of the petitioner in a time-bound way if all contentions are kept on. First off, this is a happy thing to happen in adjudicatory process. First off, in the above circumstances, petition is disposed of. Decision on the subject representation to be taken in the within 4 weeks in the light of recommendation. Which is that recommendation?
Annexure 4, my lord.
In the light of the recommendation
Information
of
of
block education officer dated
13/6/25.
13/6/2025, a copy whereof awaits at Annexure 4.
My lord.
4. And petitioner to be informed of result within the said period. First one. If delay or default happens on the part of jurisdictional authority who has to take the decision, he shall be personally liable to pay rupees 1,500 per day of delay to the petitioner for the first 1 month and rupees 1,000 for the period next following. Okay. This is the only way. There is no other go. All contentions kept open to solicit any information, etc., etc. I will avoid, but there shall be no requirement of contempt proceedings hereafter. All contempt proceedings I want to reduce in this court. Self-implementation of the order. Yes.
Maybe, pardon, representation 2/4/22.
Now,
22/4/25.
22/4/25.
My lord.
Which is that?
Page 49.
22/4/25 only. Annexure 5, na?
My lord, sir, literally 2/4/20.
22/4/25. Okay.
Obliged.
You will get, you don't mention anything. You just keep quiet for 1 year, you will get so much money. Yes. Yeah. You may not go for pension at all.
Obliged.
Yes.
Item 27.
Yes.
My lord, matter relating to engagement of vocational teachers.
Professional teachers.
My lord.
In which institution?
High schools.
In high school.
My lord.
They are not engaging you.
The petitioner, along with the other vocational teachers, have been working as high school teachers since 2016.
2016.
My lord.
28/7/25 is your representation.
My lord.
If that is considered, will it be okay?
My lord, my lord.
State project officer director has to take the decision.
Copy number 2, my lord. They are going to engage new vocational teachers without considering the experience of the present petitioners.
So preference has to be given to you.
My lord.
Where have you stated in the representation?
Representation, I have written it, my lord. Second para. It is pertinent to mention here that BT working different educational institutions have gained experience in similar field.
Which is that judgment? WP number 22.
That is the judgment passed by the Madhya Pradesh High Court.
Madhya Pradesh High Court.
My lord, by the Annexure 3.
You could have filed writ petition in Madhya Pradesh High Court only.
It is a central policy. This is a central policy.
It's a central policy.
Central scheme, my lord. Madhya Pradesh High Court judgment is Annexure 3.
Consider representation in the light of Madhya Pradesh because of which is that site, which judgment?
Honorable High Court observed that experience already working with it for the last so many years cannot be brushed aside only because of the development took place in the same trades. That is the observation.
That is observation, but I am telling something which you do not know. I am saying in respect of central schemes, if one high court takes a view, other high courts are bound by that view. Earlier, other high court judgments were persuasive. This is what we were taught. Now law has changed because of Kusumin got 2004 or something like that. The short grievance of the petitioner is as to re-engagement of his clients in service under which scheme it is? Under the Odisha School Education Program, which he says that is largely structured by the central government. First up, he draws attention of the court to the representation dated 28/7/2025, wherein he has requested the authorities for re-engagement, and the said representation according to him, remains unconsidered till date. First off, he further adds that a new set of people is being considered for engagement in the stead of the petitioners and such other similarly circumstanced who have accumulated experience having already worked therein. And therefore, he presses into service Madhya Pradesh High Court decision in WP 18481 of 2024, heard and disposed of by judgment dated 22/8/2024. Next paragraph. Learned AGA on request appearing for the respondents opposes the petition, contending that even the ink on the subject presentation has not dried up.
In fact, now government has decided to take from agencies, not individual.
Right, I will tell that also, but take a call on this.
My lord.
Ink on the said representation has not yet dried up and the petitioner has rushed to the court unjustifiably. First off, he further adds that the direct engagement of persons of the kind is not being favored, a policy decision having been taken by the government to outsource the same through agencies. First off, be that as it may, he assures that a decision would be taken on the subject representation in a time-bound way if all contentions are kept on. First, this court appreciates this stand. In the above circumstances, petition is disposed of. Time for taking decision is 6 weeks. Reckoned from this day. Next paragraph. This would include communicating the decision taken to the petitioners. Only one petitioner.
Petitioner representing
How many petitioners?
Petitioner is the secretary of the Vocational Welfare Association, representing all the members.
To the petitioner association, secretary, petitioner association. It is open to solicit information, etc., etc. Now, no courts. Okay.
My lord, no corrective action. No corrective action.
What action? Corrective action.
No corrective.
You are still continuing.
Continuing, my lord. I am continuing.
One more sentence. Learned counsel for the petitioner further argues that unless this court interdicts termination, his clients are likely to be disengaged. How clients who happen to be members of the association are likely to be disengaged?
Well, it says no application. Just not filed any interim application.
Interim application.
Prayer,
have you filed that copy?
Prayer, my lord. Prayer person I have written it. No corrective action.
In the prayer itself, you have requested not to take any coercive action.
My lord.
It is not interim, final order only. It is wiser now. Yes. Till a decision is taken and communicated, the no coercive action shall be taken against the members of the petitioner association. Okay. All right. All contentions we have kept open. You take a decision and send whatever you want to do that. Okay.
Item 29.
Petitioner in this case seeking for his transfer. He filed online application before the authority.
For transfer. But generally cases which come before the court don't transfer.
Yes, sir. So seeking for his transfer. But online application is submitted, but there has not been considered. He approves this Hon'Ble Court under Annexure 8, page 23.
They said consider.
No. They say accident. My leg paralysis. Due to that, I prayed for my transfer to.
But that paralysis will be there even when you are transferred the other place.
For that reason, I prayed for, and that has been Annexure 9, page 24. opposite party number 2 directed to consider his case to opposite party number.
But what is your right to be transferred? You have duty to be transferred.
No, because actually the online applications, the state has put one online notification. So those who wants to transfers, they
can seek the transfer.
For seek that their cases will be considered by the authority.
Where is that?
That notification, sir. Notification I have not enclosed earlier.
Have you mentioned that notification?
Yes, my lord. When Annex 8, page 23, this honorable court also mentioned.
Court also mentioned.
Mentioned.
That notification is by the state government.
Right. Every years, they notified the case and they, my lord, I have annexed the earlier. He has applied through online mode. That is space.
You consider that? Okay.
Annex 9, the opposite party number 2 forwarded to the 2 for consideration.
They have recommended.
They recommended.
But they have forwarded.
Forwarded. Annex 9, page 24.
Annex 9.
9, page 24.
Who forwarded it to whom?
So the opposite party number 2 forwarded to the opposite party number 3. This is
OP 2. Sent to?
Opposite party number 3. Page 24.
Who has to take the decision?
Opposite party number 3.
On which date it is sent?
Sir, 36/2025.
Where is your representation?
My lord, online application I have made on 28/5.
Annexa?
So that I am not annexed. I am amendment on page 5 or 28/5/2025.
19/12/24 is also there. 19/12/24. At A7.
He is approached the Hon'Ble Court against that
litigation. But petitioner who is aspiring for transfer from one place to another on alleged health ground was before a coordinate bench of this court in WP 1632 of 2025, disposed of on 27/1/2025 with a direction to make one more appropriate representation in terms of the state policy providing for transfer after the retention period prescribed under the transfer guidelines. First one. Accordingly, petitioner made, please be seated. Despite the representation, online application being made, in terms of the state policy, no decision is yet taken by OP number 3, though OP number 2 wide letter dated 30 June 2025 at Annexure A9 has forwarded the same to him. First up, he invokes the mandate of Article 350 of the Constitution of India to the effect that whenever a grievance is raised by a citizen, the jurisdictional authority has to take a decision on merits and within a reasonable period. First off, this having not happened, he submits, intervention of this court is warranted. Next paragraph. Learned AGA on request appearing for the OPs submits that he would instruct the jurisdictional officials to look into the grievance of the petitioner in a time-bound way if contentions are kept open. First up, this is appreciable. Next one, in the above circumstances, petition is disposed of. Time for compliance is 6 weeks, which should include the decision, include the time taken for informing the decision taken on the subject representation. First up, all contentions are kept open. Next one, it is open to solicit. Now, no cost, sir.
Item 30.
Delay or default may attract levy of penal costs that may be recovered from the jurisdictional official personally.
Item 30.
So 30 is also same. Only same. Sir, the date is also different only. That opposite note to send on 24/6/2025.
1 second. OP 272 3 on
24/6/2025.
24/6/25.
Earlier WPC is 5958 of 2025.
5958 of 2025. Earlier WPC. Disposed of on
Same 6/3/2025. Annexure 5, sir.
Okay. Next.
Item 31.
May I please, Your Honor? The petitioner has approached this honorable court because her representation has not been disposed of by the school authority.
Representation for?
And the change
The name of the child.
Change of the name of the maternal uncle whose name has been given as local guardian, it has been mentioned in the ID as a father of the children. This is DAV school who will carry out the
CBS.
They are sending the
Given the representation.
yes.
We direct that school to consider this representation. All right.
Oh.
And BEO to monitor it.
Yes.
BEO cannot sleep over the matter. BEO is also exercising jurisdiction over the school. BEO,
my lords, here,
is not concerned with that.
That is
CBSE.
That is CBSE pattern.
CBSE pattern.
CBSE pattern.
Whose jurisdiction? CBSE. State, I can understand.
They have their panel of lawyers, my lord. ICSE and CBSE, their panel.
CBSE board of Odisha.
CBSE.
Your lordship may direct school authorities to consider
the representation. No. Whether student is here or parent is here.
Parent is here. Mother. Yes, ma'am.
Petitioner being the mother of ward name? Sai Anmol is grieving against the non-consideration of her representation dated 25/4/2025, a copy whereof avails at Annexure 2, wherein she has sought for change of father's name of the child. In as much as uncle's name is shown as the father of the child by inadvertence. First off, these grievances, this matter need not be kept pending, nor any notice be issued to the school, since no order on merits is being passed by this court. First off, an order to pass order on the subject representation would do justice if all contentions are kept open. Come on, I'll give counsel for the petition. First off, this is next paragraph. In the above circumstances, petition is disposed of. The respondent school is directed to consider petitioner's subject representation forthwith, keeping in view the policy guidelines, and report result of such consideration to the petitioner. First, it is open to the petitioner to give one more representation, refreshing the memory of the school authorities. First, next paragraph. All sentences are kept open. Registry to send a copy of this order to the OP school immediately by for compliance. First, next paragraph. It is open to the school authorities to solicit information, document, etc. The decision taken should be communicated to Registrar General of this court within 7 weeks.
Item 32.
Petitioner challenging the approval order dated 10/6/2025.
10/6/25.
Yes, my lord. Annex 7, my lord. Issued by the DO in favor of the opposite party number 5, my lord. So he has not working till the lifetime of the service, my lord.
What is your grievance?
My grievance, the benefit is granted in favor of the opposite party number 5. So he has not working, my lord.
Where is your representation?
Not my representation, my lord. I have challenged this order, my lord.
This order?
So I have continuing. Till that I am continuing.
But now he is engaged.
No, she is not engaged. Prior to unaudited period, he was dismissed in a service.
Just look into, brother.
My lord, here opposite party is there, my lord.
Correct.
Private party is there.
We'll issue notice.
He needs to be noticed.
Issue emergent.
Because this is second round of litigation.
AGA for?
I'm for the 1, 2,
1, 2, 3.
1, 2, 3.
1, 2, 3. Emergent notice to
4 and 5 notice to be issued.
Rest.
My lord.
3 days for supplying games.
Interim prayer, my lord.
Interim prayer to?
Not to disperse the amount till the disbursement.
Let us see. Now working now.
Now I have second my lord. Second miss case. I have filed the headmaster not allow him to resume my duty, my lord.
Let us see. Let us see. Post this matter immediately after service. Okay.
Item 33.
May I please your lordship? May I please your lordship? The matters related to particular grade 1 scale of pay and reader scale of pay. And then covered by the judgment of Chittaran last case, and your lordship has passed a similar order. And I have also.
Is it?
My lord, this is covered. And to that effect, they have also filed the representation. That is there also in the order also.
That representation
is Annexure 6. Annexure 6, and your lordship may kindly. And I have made necessary correction regarding the representation of the things.
Short grievance of the petitioner.
In a synopsis, I have mentioned the details.
Reflected in his representation dated 18/3/2025.
Annexure 6.
A copy whereof avails at Annexure 6, wherein he has sought for the grant of lecturer rupee scale of pay with effect from 1/6/2023 instead of 12/8/2008. And reader's scale of pay with effect from 1/6/2013 instead of 12/8/2018 in terms of a coordinate bench decision of this court dated 3/4/2023 in WP number 8976 of 2017 between Chittaranjan Das versus State and others. First off, learned counsel for the petitioner argues that the said representation had not seen light of the day, and therefore intervention of this court is warranted. First off. Next paragraph. Kindly be seated. Mr. Monte, be seated. Learned AG on request accepting notice for the answering OPs fairly submits that he would instruct his clients to look into the use of the petitioner in a time-bound way if all contentions are kept open. First off, this proposal is agreeable to counsel for the petition, as also this court, as also to this court. First off. Next, in the above circumstances, petition is disposed of. Time for consideration of the subject representation and also to inform result of such consideration to the petitioner is 6 weeks. First off, it hardly needs to be stated that consideration should happen in the light of Chittaranjan Das case Supra. First off, it is open to solicit. No cause. Okay.
Item 34.
It's the same, but period of claims to different.
Dates are different.
Dates are different. Page 30 or 60 can only that will be changed. Go to Annex 6, page 30.
See there, with effect from 1/6/2002, lecturers rupee, instead of 25/4/2011. And readers pay with effect from 1/6/2012, instead of 25/4/2021. That much. Okay. Annex 6 is necessary material structure that just last one.
Item 35, had to pay?
Yes. 35. Yes, sir. 35. 34 same. 34, 35 same.
33, 34 same.
33, 34 same. 35? Yes, sir.
Passover.
Passover. What is this matter? Tell.
I don't know.
I will help you.
Sir, I don't know.
Take out. Is it an appeal?
Sir, I don't know actually.
No, I am asking you. Is it an appeal? You don't have you have papers now.
No.
You don't have papers also. But you are holding the papers in your hand.
Those are other papers.
Different papers.
Different papers.
Passover.
Item 36.
May it please your lordship.
Yes, sir.
My lord, the petitioner is there, your lordship. This is a caste certificate proceeding, your lordship, where the state level scrutiny committee is taking up the matter. My short grievance before your lordship that in 2000, way back there was an allegation made by some person absolutely not connected with us that the caste certificate obtained by us is not correct. That is petitioner and his family members. So the state level scrutiny committee called for a report from the Tahsildar Mahakalpada, that is district Kendrapada, and the police SDPO of SP Kendrapada.
What they say?
In the caste certificate proceeding, the report is to be given, that is the field inquiry report, as per the decision of Honorable Supreme Court in Kumari Madhuri Patel, that joint inquiry is to be done by one revenue officer and one police officer. It is a district vigilance cell committee, so report is to be given. Now the Tahsildar Mahakalpada submit a report in my favor. There is caste certificate.
That included the police officer also?
No. The police submitted a report against us. Since there were two reports, so the state level scrutiny committee headed by RDC Central Division, he said there are two reports contradictory to each other, and we have been issued notice to file our responses to such, my lord. We submitted, your lordship. Now it was discussed in state level scrutiny committee, and the state level scrutiny committee decided to call for a fresh report, directing the collector and SP Kendrapada to look into the matter personally and to give a fresh report. Now, by this time, the Tahsildar Mahakalpada, who has submitted earlier report, he has been transferred.
Next Tahsildar came.
Next Tahsildar came.
He gave report against him.
No, my lord, he didn't give the report. But the SDPO Kendrapada, who has submitted the earlier report against us and whose report has been rejected by SLSC and a fresh report has been called for, the SP Kendrapada entrusted the reinvestigation to same SDPO. The same person. Now, what he has done, your lordship, since he is a government officer and he has submitted the report against us, he simply rejected all our contention. Our prayer that we are suffering from COVID, we have submitted the report that there is COVID, our family members are suffering. He gave us 2 days time only and didn't give us any time to cross-examine any witnesses he examined, didn't allow us to produce any witness, didn't allow us to produce our documents, and he simply submitted the report which has been submitted by him earlier. He stick to his report earlier. Then when I could come to know that the SP Kendrapada has entrusted the investigation to same officer, I came before your lordship in the writ petition. This honorable court directed me to raise all the pleas. This honorable court granted a stay of further proceeding on 2nd December 2020. I communicated the order on 2nd December on affidavit that as soon as I get the order, I will submit it. And the honorable court's cause list, my affidavit, stay has been granted, communication made by the lawyer, everything was given to him. In spite of that, he submitted the report on 4th December 2020 on the ground that no order of this court could be communicated. But on 2nd December, 2 days before, I got this stay, I communicated it also on affidavit.
Now, when I raised all the pleas before this honorable court has been pleased to direct me to raise all such pleas before the state level scrutiny committee to take a decision. Now, state level, in the meantime, Your Lordship, the Odisha SC caste certificate verification rule 2023 came into force. That is applicable to pending cases, applied to my cases also, that is not disputed. Therein also there is a provision that when a joint inquiry report is submitted, it is to be examined by the state level scrutiny committee whether it is to be accepted or not.
It's a joint level inquiry committee.
My lord.
But not separate inquiry.
Not previously separate inquiries were done. Thereafter, the joint inquiry was entrusted to the same SDPO who has conducted the earlier investigation. My respectful submission, Your Lordship, there are judgments of our own Hon'Ble High Court that when an investigation under the caste certificate scrutiny committee is to be done, therein we must be given to chance to cross-examine those witnesses whom he is examining. They are to be examined in my front, they have to be examined. Because the reason, Your Lordship, one 35-40 years old person saying that 1972 our family came from West Bengal, settled here, and he knows it from his own knowledge. That I am required to put a question that how 35-40 years old person can know from his own knowledge what has happened in 1970 and before that to my forefathers. So that he didn't do.
Suppose we believe that Alexander had come to India in BC 323.
My lord,
we had not seen him.
My lord, that is from public history, my lord, we are knowing.
That's all. Like this, there will be some source.
But Your Lordship, I am also required to produce my witnesses. I am also required to produce my documents, Your Lordship. Now only 2 dates, short dates, 3-4 days he has given. Even I have annexed my documents that I am suffering from COVID, my family members were suffering from COVID. My respectful submission, my lord.
Let him take notice. First time it has come.
First time.
It is the 7th time.
No, my lord.
Yes, my lord.
No, I am submitting.
I
am submitting, my lord.
First time.
But I
this
can.
is the first time after honorable. Let me submit. This is the first time, my lord.
All right. You take notice.
My lord.
You write one sentence that this is 7th time he has come here.
Yes.
I will examine that.
Yes.
All right. You are a special counsel.
No, my lord. I am from opposite party number 6.
OP6?
Yes.
Other official.
I am the complainant before the SLC.
1 to 5.
1 to 5.
Monty, on request, accepts notice for 1. Shri, so appears for OP number 6.
Yes.
OP number 6, who happens to be the complainant.
Before the SLC.
Before the state level scrutiny committee. First off, pleadings to be completed within 3 weeks. That Madhuri Patil 95 Supreme Court.
My lord.
That issue was already discussed in several order of this honorable court.
No, that is not.
And my lord.
Anyway, now notice is given to you. You can write your story.
Yes.
We'll look into.
And what my learned has submitted, already SLC give their time to cross-examine. Already order dated 9/7/2025.
You write that.
Yes.
So that we will write that in our judgment, so that we can consider on merits itself.
Okay.
But what he says, even Socrates said, right of cross-examination is very important.
Yes, already they have given.
No, I'm just.
No, already date is
unless that is part of the brother.
My lordship.
Why can't you learn little advocacy? You should learn little advocacy also in addition to law.
Yes. Because the next date is 20 August 2025 for the cross-examination.
You in the meanwhile, you cross-examine.
My lord, that is for the SLSC. My learned brother is not saying, Your Lordship.
The authorities.
Yes, my lord. My prayer is before the investigating officer. The SLSC has called, which is one-sided report, and I didn't get a chance to object the inquiry report which has been submitted.
No, you can file your objections.
That objection I filed.
You have to keep quiet till judge completes his speech. Why that culture is not developed in your part?
My lord.
We also have limitations of patience. Communication. What judge is saying.
My lord.
What judge is saying is very important to you. Not lawyer is saying. Is it not? You should hear. What is his requirement? Any standard book on art of argument by Gerald, etc. They say like this.
Right.
Yes. Now, the report was called for. Report he prepared behind your back. Maybe you were present there. We do not know. Your contention is who all were examined by the person who reported. Those persons need to be cross-examined. That cross-examination need not happen right in front of the person who recorded their statement.
My lord.
That can happen before the committee.
Exactly.
This is what he said. Yes. Therefore, on that day, now date is fixed in
20 August.
20 August.
Yes.
You cross-examine them, subject to outcome of the proceedings. I will not stay the proceedings. Because Apex Court said, right of cross-examination can be given in appellate stage also. In caste matter only. I do not remember. It may be Laveti Giri versus State of Andhra Pradesh, something like that. I do not remember. Justice B.S. Chauhan's judgment. Okay. Look into that.
May I submit a small prayer?
Yeah.
My lord?
Yes.
My lord. My lord, my respectful submission before your lordship that when the inquiry is conducted by the investigating officer, in that case, particularly in caste certificate proceeding case, I have got a right to cross-examine those witnesses.
Correct.
What has happened, my lord? Now, when a government officer is directed to submit a report which he has submitted earlier a contradictory report, it is very obvious, your lordship, that he will stick to his earlier.
No, we don't believe that.
That is my contention, my
It's your contention, but we don't agree. We reject your contention.
My lord. So far,
In case of remand,
my lord.
did you see? You remand this to some other officer?
Yes, my lord. That is exactly
Was
my
it
prayer.
granted by the court? It
No.
was not granted.
That is-
The court said you reject. You take up all contentions before the SLS.
Yes, I took. And SLS, that is exactly.
Let us see. We have seen that.
My prayer before your lordship.
Now, no case is made out for issuance of interim prayer. Next item.
My lord, my prayer is that, your lordship, on 20th.
You have said that.
On 20th, my
What is the admission matter? We hear you only limited. These are all 227 matters. These are not appeals. Only 227.
Only, your lordship, 20th I may be permitted to take a time.
No,
because my learned brother has to call the witness. He is there. The witnesses have not come.
If they come, you cross-examine.
Yes.
Subject to outcome.
Yes.
I may be permitted to take a time.
I don't say anything. If they give time, well and good. Suppose if all the witnesses have come and if you ask time, again and again, who will bring the witness?
He is there for the witnesses. I am ready to deposit the cost. If they are again called, your lordship may record it.
You make that prayer to the concerned authority. They will decide. Because they are recording the evidence.
Your lordship may kindly permit me because they are not allowing, your lordship. My lord may record my submission that if witnesses are required to call, I will deposit their cost, my lord. I undertake, my lord.
No,
Then your
made out for interdicting the ongoing inquiry at the hands of state level scrutiny committee. Item participant.
Then my prayer for time may be considered.
You make a prayer there.
No, they will not consider, your lordship. The difficulty is that because I am before your lordship, they are not considering. Only your lordship may observe that I will make a prayer for time, they may consider.
No further observation required. Item 37.
Published.
May I please, Lords?
No.
Lordship, order dated 7/5/2025 under Annexure 3 is under challenge before my lords.
Annexure 3.
My lord, page 17.
What is this?
That
Prakash Chandra Mishra, Devashish Patra.
Yes. I am challenging the nomination of Devashish Patra to the syndicate on the ground it violates the Odisha Universities Amendment Act 2024.
Both are
only in respect of Devashish Patra, not Prakash.
Both are nominated as Senate members.
Syndicate
members.
Vice Chancellor has nominated them.
Vice Chancellor is the authority.
Yes, Vice Chancellor is the authority.
But number 2 does not have requisite qualification.
No, he had the requisite qualification. As per the Amendment Act, 2 professors are to be nominated on the basis of seniority. One from science stream, another from arts stream. The lordship is that Devashish Patra, he was promoted to the post of professor in the year 2023. I was appointed as professor in the year 2017.
So you are senior.
Yes, admittal, you also you can find it from Annexure 1, my.
Which rule, which section you are reading?
Yes, I am reading that. You'll also see that Odisha University Amendment Act.
Have you produced that copy?
I have annexed that.
Thank you.
You also can find it.
That annex.
Yes, madam. It starts from page 53, madam.
Which section?
Section 10H. It is at page 65. You'll also may see.
65.
Madam. You'll also may see B for clause H.
The following clause shall be
substituted, namely, 2 professors of the university, 1 from arts or humanities stream and 1 from science stream to be nominated by the vice chancellor on seniority cum rotation basis.
Seniority cum rotation.
Yes.
Basis. Once you and next time he may be, even if he is a junior.
Yes, because in different subjects are there in arts. So on the basis of seniority,
were you syndicate member at any time before?
No, this is the first time. First time in the 2024. I am.
Who appears
for opposite part number 1, government is to accept.
But already 3 months are over.
Yes, Mala. 3 months have 3 months in the meantime. I reprinted to the chancellor, to the honorable chancellor.
Take emergent notice.
Yes. If your lordship permits, I can serve 2 copies for opposite part number 2 and 3 on the associate of.
In addition to taking usual steps.
Mr. Dayananda Mahapatra, senior counsel, who appears for
emergent notice.
To opposite part number 4, your lordship.
Matter relates to nomination to syndicate of the university.
FM University. Fakir Mohun University.
OP.
FM University.
No, OP number.
Yes, OP number 2.
OP number 2. 2. 4. 2. OP number 4. University. OP University. University. First up. Mr. Mohanty accepts notice for
what? OP number 1.
Emergent notice to the rest. First up. In addition to taking usual steps, petitioner to serve copy of the petition along with all the documents on the panel counsel, Sri Mahapatra.
Yes, madam. Dayananda Mahapatra, senior counsel.
Mahapatra appearing for the university. University. First one. Call this matter immediately after service. Okay.
Item 30.
Challenging the order of transfer on the basis of recommendation of the MLA. I have corrected, madam. Correct.
Which date we have put all these?
2nd week of September. I have given that number, madam.
You have corrected everything?
I have corrected, madam.
As it is.
38, 39.
Mohanty, for all respondents?
No, yes, madam.
Similar that impugned order, the last para. In view of the above discussion, fact and circumstances, the claim of the petitioner for consideration for cancellation of his transfer order dated 18/6/2025 is examined and the district education officer Baleswar is directed to check the viability of the people teachers ratio in the nearby deficit teacher school of Simlia block other than the Kupura UG-UP school and accordingly give him posting on the due approval of the collector company.
That is the violation, my lord. Our institution, but we have 8 teachers and having 7 teacher deficit school and guideline, my lord, decided that deficit school teachers cannot be transferred in view of the guideline. And on the basis of the recommendation that has been transferred. My lord, kindly see page 48 for a moment.
Let us see. My lord. You take notice. We'll call all these matters.
2nd week of September.
Okay. Call these matters along with WP number.
I have given
that WP number. That one. Okay. Item 40.
May I please, your lordship? Your lordship, I am a student and I am constrained to approve.
We are all students only. Judges, lawyers, everybody is a student only. Your client is also student.
Because of the inaction of the authorities, your lordship, In the year 2023, I completed my high school certificate examination. And in 25, the Lordship with 95% of marks. 95% of marks. And in 2025, the Lordship, I appeared the CHSE examination in close to science stream, the Lordship. I secured 89.4%. So as against the rechecking, your Lordship, may I take your Lordship to Annexure 1? I'm just referring to Lordship. Annexure 1, your Lordship, may kindly turn to. My HSC mark sheet, your Lordship, may kindly see.
I believe you. Why should I doubt you?
Just 1 to marks, your Lordship. In Sanskrit, 100 out of 100.
Yes.
In science, 96 out of 100. This is HSC mark sheet, your Lordship.
Yes.
Almost in every subject, I scored excellent, your Lordship.
Yes.
Now, Annexure 2, your Lordship, may kindly turn. In CHSE mark sheet, your Lordship, getting 96% of marks, 95 to 96% of marks. Now I got only 89.4% of marks. So I had Annexure 3 when the rechecking notification was floated by the CHSE, your Lordship. Annexure 3, your Lordship, 23/5/25. I applied in respect of almost all subjects, your Lordship.
Applied for?
Applied for rechecking. With
Rechecking.
Rechecking, your Lordship.
It's not revaluation.
It's not revaluation. Rechecking and re-addition, your Lordship. So in rechecking stroke re-addition. Re-addition, if any.
That is retotaling.
Yes, your Lordship. So by depositing next annexure, your Lordship, sees Annexure 4. By depositing the statutory fees as fixed, your Lordship, I applied in respect of 7 subjects, your Lordship.
1,400 rupees you gave.
Yes, your Lordship.
Then what happened?
Then, your Lordship, Annexure 5, dated 24/7/25. The revised, it's a change of marks.
They changed also.
Change of marks. They changed, what they have changed. In the middle page, page 26, your Lordship, my serial is at 1682 and 1683. So 1682, my serial number is at 1682 and 1683. In respect of physics, I had secured 54 marks, so only 1 mark was added. After rechecking, only 1 mark was added, so 55. I got 55.
Yeah.
Then in Sanskrit, I had 74 and 1 mark was added, 75. So only 2 marks in total.
How many more marks ought to have been given to you? It may happen.
Millard, I was, because the questions are multiple choice type. And their questions are multiple choice type. And there are Lordship also knows there is valuation sheet. And I could not access to that proper valuation sheet. And there is prescribed answer to every question, your Lordship. It is not that I wrote something strange, so foreign to my subject, your Lordship.
In Sanskrit, what were the questions? Tell me.
Questions I have applied, and I have also got the Xerox copies of the. I have marked in my read petition, your Lordship.
Just I'm asking you. Just read that.
Yes, your Lordship.
What is the question?
Questions.
And what was the answer?
Paragraph 12, your Lordship, may kindly turn to. Paragraph 12 of the read petition.
Page?
I have page 8 of the read petition, your Lordship. Page 8. It is not out of place to submit here that the petitioner has also earmarked particular questions in respect of the.
Which is that particular question?
Questions I have not earmarked in the read petition, your Lordship.
But the prima facie, how are you going to judge? You should have said, who is the author of Abhignana Shakuntala?
Lord, I have only
like this you have to.
I have only numbered the question. In my application for rechecking, I have only numbered the question. My
that will not help you.
My the father, your Lordship, next annexure, your Lordship, may kindly turn to. Next annexure.
What is the physics question?
Annexure 6, your Lordship. Annexure 6 series, your Lordship, kindly turn.
Annexure 6.
6 series, your Lordship.
What is this?
This is my guardian has given it to the control of examination. And the next page
they have given 1 mark is the question. I am asking you, what is the question which rightly you answered, but they say wrongly? Which is that question?
Particular
evaluation we cannot understand.
I understand.
Still, I am moving 1 step forward, perhaps leaving the traditional beaten path and going astray. Just I want to ask. I also studied. I am a science student. If you tell which is that question in physics, I may be able to recall my school days.
What is the question and what are the answers given by the?
You have to tell that, na? Suppose he says, who invented the electronics? He writes, no, it's James Rutherford, but it is actually Chadwick. I would, so that the judge will be able to adjudge.
I understand, Lordship. I follow you, Lordship. Milord, what is here, what I just want, my application since pending, let there be direction to consider my application. Because I have given,
consider my, these courts are full of consideration orders, but not even one is being considered properly. Consider, pull down the moon, pull down the rainbow, consider the representation. How we are going to pull down the rainbow?
If need be, I can file an affidavit to that effect as to what are those questions and what are my answers, Your Lordship. I can file an affidavit. That is no problem, Your Lordship. But since my application has been forwarded to the opposite party, Your Lordship, with the specific numbering of the questions, I have numbered. These questions have been...
We cannot undertake because of Apex Court judgment in Ghanshyam Das case and a series of such cases.
Yes, Your Lordship.
We cannot direct re-evaluation because we are not in the campus. We are in the court.
Yes, Your Lord.
All right. Campus has got its own sanctity where campus people will do their job. We cannot undertake whether it is rightly answered, wrongly answered. We do not know. At least others can assume that we do not know. Is it not? But only so far as totaling, recounting, yes, we are entitled. Suppose one question is answered, but that is not valued at all. Then we can interfere because it is not a case of re-evaluation. It's a case of valuation.
Lord, had I have the access to that particular valuation sheet, I could have justified, Lordship.
You have not, I am sorry to say.
Yes, Lordship.
Very frugally written writ petition. How in educational matters writ petition should be drafted. You should say which question you have answered rightly. Which question they say wrongly answered. Even that is not pleaded. It is pleaded as if it is some cattle trespass act. Cattle went to the field of Mr. Jaina and Mohanty arrested the cattle, detained the cattle. And therefore direct Mohanty to release the cattle now.
No, actually,
it cannot be the right.
Actually, in paragraph 12, Lordship, in respect of every paper I have given, in physics paper, I am to get another 6 marks. In chemistry paper, I am to get another 7 marks. Likewise. But question wise, I have not
question wise, you should say. That is how education matters are drafted. Na?
Yes, so Lordship is right.
Should be that is right. We should feel, yes, something new is written. I should look into. That attraction is not happening. Yes. Anyway, take notice, emergent notice. Who appears for the, who are the parties?
Controller of examinations.
Controller of examinations by AGA.
Yes, so
no.
Order plus 2. They are the panel of counsel.
Panel advocate.
Plus 2 counsel. This is examination, controller examination plus 2. Plus 2 counsel.
Issue emergent notice. In addition to taking usual steps, petitioner to serve a copy of the petition on the panel counsel who usually represents the OPs. Call immediately after service since matter lies in a narrow compass. Okay.
Item 41.
May I please,
Yes.
It is transfer matter. Petition seeking challenge is transfer.
Teacher transfer.
Teacher transfer.
Covered by judgment.
Covered by judgment.
My lord, it will be posted to that September.
Issue.
Second week of September.
Stay of impugned the transfer so far as the petitioner is concerned. First of all, coupled with the direction to continue petitioner in the same place, at the same place, wherein he was working immediately before the issuance of transfer order, till next date of hearing. Call this matter along with WP number
20875 of 2025.
20875 of 2025. Okay. Yes.
Item 42.
Copy me course of the table. Obliques.
Highly pristine.
In all matter, the copy to be acted. Okay. Final order, interim order. To act upon the court order. Yes.
My lord, highly petition for restoration. Order dated 15/10/2019. My lord, batch of case already.
Similar matters are.
Yes, my lord.
Well, that order we have made. Do you have that copy of the order?
Yes, my lord.
Same date. Yes, my lord. You change, see that in that you make appropriate change in the.
Yes, yes.
All those orders are recalled.
Yes.
Make that appropriate.
One defect is already there, my lord. One book is for condonation of delay.
Application for condonation of delay.
Yes.
We have condoned how many days delay there?
Ninth month, my lord.
Right. In this case, how many?
9th month.
9 months only. In all these matters, 9 months only. Coordinate bench.
Yes, my lord.
That is also mentioned, na?
Mention.
Same order.
One book, my lord, Mulla or contract for one book, my lord, condonation of delay.
Which book you are giving?
So Mulla contract law, my lord.
Mulla and Palak.
Yes, my lord.
That is already given now. That you have to change now.
Change now.
Huh?
Yes.
Which book you will? Which books you have read in your law days?
Professional
Professional ethics.
Yes. The professional companies.
Application of professional.
Application of
Professional. Barak. One barak.
Good book you suggest. You man,
CPC, my lord, one CPC.
CPC.
Yes.
We have already done. We have enough CPC. Only thing is we don't have readers. Can you bring readers to the library instead of books? Give C. Rajagopal Acharya's Mahabharata. It's a good book. Chakravarti Rajagopal Acharya's Mahabharata. Remaining set. Next. Item 43.
Make his lordship.
Same order. Different order. What is this?
Lordship, matter is to restoration, but I apologize, Your Lordship. I don't have the file with me. It has been misplaced. Lordship, may kindly let it come next week.
Next week you want to do?
Lordship,
2 weeks.
file.
For retracing the office file and making submission as requested by learned counsel for the appellate.
And to survey copy also.
Give copy also. If you don't have copy, you can take copy from our registry. Registry to furnish a copy if applied for. Okay. Call up to 2 weeks. 44.
May I please, Your Lordship? Lordship, this is for orders item. Your Lordship, kindly have a glance to the flag A.
Flag A?
Yes, Your Lordship. Let IA for impleading party, opposite party number 4, Principal of District Education and Training, Jajpur at Dolipur. For impleading.
You want to implead him?
Yes.
Why?
Your Lordship, because the petitioner is working under him, Your Lordship.
No, what's your prayer?
Your Lordship, prayer for disbursement of arrear, Your Lordship.
Disbursement of arrears.
Arrear salary.
So you want to implead him?
Implead as a opposite party number 4. Kindly glance to.
So who passed that 16/5/24 order?
Your Lordship, that is OP number 2, director.
Then that will be sufficient. Now, why this person you want him?
Yes, Your Lordship, because the petitioner is working under him.
Application supported by the affidavit seeks impleadment of another official who has something to do with the impugned order dated 16/5/2024, whereby the petitioner's prayer is rejected by OP number 2. OP number 2. First, learned counsel for the petitioner presses into service the apex petition in Rajia Begum versus Shah Nawaz Begum, AR 1958 Supreme Court, to contend that OP number the person who is now, the official who is now sought to be impleaded, answers the definition of the description of proper party, comma, if not necessary party. First, no objections are filed to the subject application seeking impleadment. It has come for the first time.
My lord, so you have filed counter.
Counter you have filed, but impleadment application. No. First, some case is made out for impleadment. Next, in the above circumstances, application having been favored, petitioner is permitted to array the person named in the subject application, official named in the subject application as the OP number 4. OP number 4. Immediate. And file amended cost title as well. You have to amend and file the amended cost.
Yes.
Two things have to happen under CPC.
Yes, sir.
Not just filing the amended cost title. Yes.
Grateful.
This to be done within 2 weeks.
Grateful.
Item 45.
I have filed for what? Omission of party. Deletion of party.
They want to lead the party because 4 is the private party. Another my learned friend possibly want to be implemented.
Before my learned friend starts, my learned friend opposite party number 4 has filed a counter. That copy has not been served on me. Just now he has served.
I served.
Just now he has served.
You go through and we'll make sure.
Next week it can be taken up so that
let a copy be served upon us.
You have to give copy. Whatever copy. See, everybody should.
Yes, ma'am. That's to exchange of copies so that will be all right for us.
Course of the I can.
Yes. I will not make order. I believe it.
Yes.
Okay. Call this matter week after next, along with all the pending applications.
Yes, ma'am. In this, if he has filed any, I'll let him give a copy to me also.
They are saying that
because I am the petitioner, I am entitled to
this specific date.
After 2 weeks, it will come. We're difficult to give date because we do not know how many matters we are doing now. But I given the one more copy. Okay. Yes.
Item 46.
46.
The petitioner was directed to file the requisite to issue notice to the Staff Selection Commission OP1, my lord, by 9th May. But I have filed on 14th May. There is 5 days late, my lord. And office has not issued this notice.
The reissuance of the notice.
Reissuance of notice, man. Whatever you have furnished, notice is already issued. You have to give furnish.
Not issued, my lord.
No notice is issued.
The notice said that is pending, not issued.
Fact remains, they are panel of lawyers. Unless notice is issued, they cannot alert the concern panel lawyers.
Hey, send
issue notice to.
No, no, sir.
Issue notice to OP number 1 alone, it was issued.
Only OP1.
OP number 1.
Other piece.
Other office has submitted that we have nothing to do with this. Staff Selection Commission is doing the selection process. So notice be issued to them, Staff Selection Commission.
Issue notice to other OPs.
Only 1 minute.
OP2.
OP1 minute. Staff Selection Commission.
So OP1 is issued now.
The notice said that not issued.
Considering the instruction point, this court is inclined to issue notice to OP number 1 by speed post.
I have filed the requisite already, my lord.
They have delayed in filing the requisites. For that purpose, it could not be issued.
Delayed filing of requisites to be accepted and notice accepted and on 7/5/2025 to be processed immediately.
May I pray once? Mr. Patnaik is also appearing for a Staff Selection Commission associated there.
Then formal issuance of notice is dispensed with. Since Mr. Panel Counsel, Mr.
S.N.
Patnaik accepts notice for OP number 1. All right. Copy you received?
No, man.
Give copy. Copy of petition along with all the papers to be furnished to panel counsel, learned panel counsel right now. Call up to 3 weeks. Okay.
Item 37.
I am a lordship. 47. My IA for vacation of stay is listed on mention. But I am there for the petitioner.
You are for the petition?
Yes, I for the opposite party number 2.
You are for OP1, you are for...
I am for opposite party number 3 and 4.
3 and 4. You are for 2. One is for government.
One is state.
In this case, 7/4/25, order has been passed. This is regarding environment matter, madam. CNG
establishment of CNG, reproduction of a CNG, madam. Lord, my lord,
order has been passed on 7/4/25
order
Yes.
has stayed the construction of a CNG station being established by GAIL India Limited. I appear for opposite party 3 and 4, who are officers of GAIL India Limited. GAIL India is not impleaded as a party. Let the main grounds on which the writ petition seeks the relief.
Let me place that.
Let him argue. We can finish up the matter itself.
My submission is, my lord.
So, Milord is said.
Yes.
What's
your contention? GAIL India is not made a party.
Yes, my lord. GAIL India is made a party. Instead of GAIL India, the chairman and managing director GAIL India Limited
is made a party.
Made a party. So my London friend suggested that GAIL India should have been represented by chairman and managing.
Companies Act, A. Ramaiah says.
Yes.
A. Ramaiah, a great author on companies law.
There are 3 judgments directly, 1977, year 2003 Supreme Court 805, and now a recent judgment of September 24. They all say the company is a juristic person.
Correct.
And the officers of the company cannot substitute the company. If a relief is sought against the company, then the company has to be impleted. Here they seek the relief of cancellation of an allotment made by the state.
Let us see that. Yes, no, he has answered. That's the way.
My lord, here the Pollution Control Board is the main body because the GAIL India has started construction of the CNG station.
What is the stage of the construction?
Construction has started. It has not yet been completed.
Completed means putting up the tiles.
They have certain development. I have also given the photographs. If your lordship can see the photographs, that is not disputed, my lord.
Who are you?
I am a resident of the neighborhood, my lord. Neighbor means my lord, next door neighbor. Just at a distance of 5 meters, my house exists, my lord. I am residing there. They have started the construction, my lord, adjacent to the house of the petitioner. So it is, my lord, if your lordship will see Annexure 5, that is the photograph I have given, and that has also not been disputed by my friend.
It is almost, this is your house, sir?
Yes, my lord. They have constructed in this manner.
Well, where is their construction?
Construction is, my lord, your lordship may see the structure. That is the construction. A plate is there and the roof is just cast.
It is almost completed.
It is almost completed.
Now you want to pull down?
No, my humble submission, your lordship may kindly consider, my lord. The land over which the CNG construction is going on, that is a gochar land. That is a communal land. And I have challenged the order of the GA department in giving lease of the land in favor of GAIL India for establishment of the CNG.
GAIL India was a government company.
Well,
yes, my lord. Central government
company. Yes, my lord. Well, how come? Because the communal land can never be granted on lease for any other purpose. Well, that is also the law.
This see the structure, how big it is.
Yes, ma'am.
Just show it to your friends.
Yes, ma'am.
Just show it to friends. At the earliest point of time, had you come?
No, no. I have made several representations. I have approached different authorities. When they did not respond to my representation and they did not consider, you know,
slowly we can go.
Yes, ma'am.
One by one we can go. Which was your first representation?
First representation
was given.
Is Annexure 3, madam.
First representation I am asking.
No, sorry, madam. First representation is
3/7/2024, perhaps.
Yes, my lord, that is Annexure 2.
Annexure 2.
At page 11. That is the first representation which was in my possession. I don't know whether any other representation was made before that or not. But that is the representation that was made on 10th March 22.
No, this is made on
10th March 2022.
First one is 10.
At page 11, you also may see.
1 second. 10/3/22.
This was made and the signature of the petitioner, they have also admitted it. The petitioner signed along with others. The grounds on which the representation was made was the inhabitants of Kanon Bihar and Sri Bihar appealing you that GAIL India authority constructing illegal gas pipeline near residency area without consulting or any public hearing and any notification to the inhabitants of this area. So far as safety norms is concerned, such kind of unity cannot construct nearby residence area and minimum distance of 100 meters from petrol tank and residence area. Secondly, EIA risk analysis study should be there. The GAIL not following this process. Thirdly, main road is there, which is very much risky.
Any objections are filed by them now?
No objection filed.
No objections are filed.
They didn't.
Objection to?
They
Objections to
didn't.
main matter. The counter to main matter.
Counter is filed.
Filed.
Counter is filed. I have got
They have filed their counter. My humble submission is, my lord, they have constructed a buffer zone has to be maintained, my lord.
Where is that requirement?
That is the CPCB guideline, my lord.
Show that.
That I have not been able to get. But my learned friend who is appearing for Pollution Control Board, they have not filed their counter, my lord. So the CPCB guideline that abhorrent I have taken, that paragraph 16, when the State Pollution Control Board should not have granted permission to such a project at such a residential area, as it is a clear case of violation of CPCB norms.
Where are those norms? You have to make out.
Central Pollution Control Board norms.
Those you have to make out.
That I have to, well, that I have not been able to get. I will bring that, my lord.
No,
as for the.
You will bring when? After judgment is over?
No, not after judgment. Today certainly it is listed, man. I could not win.
Yesterday, no.
Yes, my lord.
Yesterday it was circulated.
Yes, my lord. So I could not find out immediately.
Will you be able to bring it?
Your lordship, allow me 7 days time at least. I will.
There is no guideline. Short term. There is no guideline.
Let them file their counter. They say that there is no guideline.
No,
they have not filed their counter.
The guideline he is quoting, that is regarding petrol pump, not for CNG. CNG must valid this particular.
CNG pump is different. Different.
But no, there is also a petrol pump.
Submission, there will be no petrol pump.
There is also a petrol pump.
Petrol pump is also there.
Yes, madam. That is there.
Petrol pump.
Have you contended that in your petition?
That is there in the representation.
What he says is across the road. And this contention regarding violation of CPCB guideline, firstly, does not apply. Secondly, this is the subject matter of a proceeding before the National Green Tribunal.
Yes.
Matter is before the Green Tribunal.
I have not approved the Green Tribunal.
You might not have, but others have.
The officers have approved.
Suppose if I hold all this is correct, and Green Tribunal will not be able to.
I am personally accepted. My house is completely shadow.
But you go before the Green Tribunal only.
My lord,
we'll permit you to get implemented in the Green Tribunal.
For the self-same area, for the construction of same, one OA of 19 of 2025, which is pending before the National Green Tribunal.
That is what they are saying.
His next door neighbor, my lord, the first representation.
We are first contention we are treating. Yes. You are saying matter is being deeply examined by the Green Tribunal. Green Tribunal, you have seen the judgment of the Apex Court in Sri Ravi Shankar versus so and so. Green Tribunal is the right body for this purpose. Is it not? Yes. Therefore, you go and get implemented. We will make observation.
But the dispute, well, he's personally I am happy.
Even personally I am happy. Green Tribunal need not be only PIL. Green Tribunal will have the take out that act, which is that Air Pollution Act.
National Green Tribunal.
National Green Tribunal.
Green Tribunal Act section, which is that 14. Read.
Just one thing.
1 second. We are considering one thing now. We'll go to next thing after considering.
Also, the NGT number is also.
That's what we'll say. That NGT number.
Number is my order. 19 by 2025 EJ.
OA number 19 by 2025 EJ. Before the National Green Tribunal, Eastern Zone, Kolkata.
My lord,
Eastern Zone.
That application is annexed to my counter affidavit. My lord can see it.
Kindly read 41.
Yes.
14.
Tribunal to settle disputes. The tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to environment, is involved, and such question arises out of the implementation of the enactment specified in Schedule 1. Subsection 2. The tribunal shall hear the disputes arising from the questions referred to in subsection 1 and settle such disputes and pass orders thereon.
But environment. His case is not of environment. His case is my house is beside.
His principal case is there is a violation of Central Pollution Control Board guidelines. That is what he was saying.
That is one of my.
Which is issued under the Air Act and the Water Act pursuant to a direction by the NGT.
Section 18.
And
Section
18.
18.
Read.
Air Act. Application, yes. Section 18 of the Green Tribunal Act. This is application or appeal to tribunal.
That is after the order is made. He says it's not question of environment. It's a question of my house, my building.
My lord, can I give a short background? Lord, the first representation that was referred by my learned friend was 10.3.22. That is at Annex 10.3.22.
Annexure 8.2.
Annexure 2, page 11.
Correct.
Now, after that representation was filed, a writ petition was filed assailing inaction of that representation. The petitioner is a signatory to that. A PIL was filed. The PIL was dismissed for default. Then this application before the Green Tribunal was filed.
In PIL, whether he was a party?
He was not a party.
I was not a party.
He was not a party. He was one of the signatories to the initial representation. The first three signatories to that representation of 10.3.22, one came to the PIL, one went to the National Green Tribunal.
One is here.
One is here. And the applicant before the National Green Tribunal and the petitioner, they are next door neighbors and similarly situated in all aspects as far as the construction is concerned. My lord, the conduct is in question, and this application before the National Green Tribunal, that is also annexed to my counter affidavit. It will indicate that the grounds that are being advanced here are more or less covered there.
No, that is not correct.
Apart from that, there is the question of safety. He has raised the question of safety, saying that a CNG station coming next door to my house will be hazardous. In that regard, my lord, this is regulated under the Gas Cylinders Rule 2016, under the Explosives Act. And the present position is premature. Under those rules, first a layout has to be drawn and an approval has to be procured from the Petroleum and Explosive Safety Organization, PESO. And then the construction is undertaken. And after the construction is completed, various other licenses and approvals are to be procured before the CNG station can be commissioned. So, as
building is constructed.
No, my lord, building is not constructed. That building that was shown at Annexure 5 is the building of the petitioner. What my lord can see from Annexure 5, this is
Annexure 5.
Yes,
Annexure 5 at page
16.
15 is
building.
My lord, building belongs to the
petitioner.
Your building it is.
This is my building, my lord.
That is
construction.
Which has been alleges to be the construction or this fabricated structure. It's just started and stopped.
They say that permission will be.
And in fact, the adjacent plot of 457, that is the massive construction is coming up on that side. This is a small plot, 30 decimals. The Lord can see the photograph that has been annexed.
They have not received obtained permission from the authority. They say that after construction is over, they will ask for permission. So that is their case.
Each state is like that. What can
my humble submission, your lordship, kind.
No, I have an humble question to you. My humble question to you is, which policy prohibits establishment of CNG station?
That I will examine. That is why I was
your house.
That is why I was asking. Well, that is CPCB guideline, madam. That they have highlighted. There has to be a buffer zone.
Minimum saying orally.
I will satisfy your lordship.
Everything has to be in writing.
Yes, madam. I will give it. Lordship, allow me 1 week. I will give that CPCB guideline. And
when you have drafted the petition without the...
Well, I have referred to that, but I referred. Downloaded it, but it was not complete, so I could not annex it. I will find out, my lord, that guideline, and they have to maintain the buffer.
One second. All right, we have understood now. Any CNG stations are established beside the house of any citizen in the country?
Lord, that I am not instructed or informed. As of now,
tomorrow, suppose some blast happens, what should happen?
My lord, I understand that point.
Therefore,
my submission to that, my lord, is that this is established only after inspections.
no, that's all right. We need not wait till then. Thereafter, then we will ask, what were you doing all these years? He has come earliest to the court. If he comes earliest, you will say premature. If you come later, you will say he is belated. Where he should go? Now you tell us whether in the country, whether you have established any CNG station beside house of any citizen in the country. Because it's a national level organization.
My lord, distances are also specified under those gas cylinder rules.
So you give copy to him.
I will.
Under the rules only.
Under the rules only, the license, eventual license that will be granted in Form G of the gas cylinder rules.
What is the distance to be maintained
minimum
between
distance
the house and the?
Minimum distance is minimum safety distance of 4 meters shall be kept clear all around the standalone composite CNG dispensing unit.
4 meters from? Reckon from what point?
From the composite CNG dispensing unit.
That is from the unit.
Dispensing unit.
But what about the entire structure to be built beside the house of the citizen? Suppose if you bring that, which is that famous judgment of English court.
Reliance versus Fletcher.
Correct. Reliance versus Fletcher. Reliance versus Fletcher.
Strict liability.
Strict liability. Suppose if you bring, the judge gives one example. If you bring a dangerous animal beside my house, beside my quarters, you want to keep the Bengal tigers, then I am entitled to object to that. When I go in the morning walk or in the evening walk, the tiger may jump my compound and pounce on me.
Absolutely, madam. Stringent, make stringent William League case. Absolute liability.
Correct.
But my lord, my submission is that there is a regulatory structure.
You entire thing, you have to completely sit together first. You have discussion on law. Then you come before us and argue. That's the best way. It is not that it's not a game of chess.
Correct, absolutely appreciate. My lord, the regulatory authorities, the number one from the safety angle is the PESO, union government, represented by the learned.
Who appears for the union government?
My learned friend also appears for the union.
In this matter, union government is always destitute.
Yes, my lord,
we have seen them.
The learned DSG. The learned DSG, I think he has not made the union government a party in this regard.
You implead a union government. Brother,
my lord,
you implead union government.
But here, my lord, specifically I challenge
you don't want to implead.
No, my lord, I will implead. I will implead.
On that ground itself, case will go. We are showing some concession to him because I want to know whether such but question is whether it is a dangerous unit or not. Since it is a gas, generally gas is a hazard. Whichever gas.
Therefore, it is regulated. I can appreciate
that regulation has to be there.
Yes, sir. No, sir. Yes, sir. My lord, in fact,
there is one famous book by Upendra Bakshi, Professor Upendra Bakshi, Mass Disaster and Law. It is published by Indian Law Institute. Just look into that also, in addition to bringing your this. All right, we'll call this matter next week. Next week you will place everything with the court.
Next Monday. Yes,
Monday.
Final disposal.
At the request of counsel for the petitioner to come with full preparation.
Interim
order. Come with full preparation. Interim order to continue till Monday alone. Only Monday. Item 14. You have to answer whether beside the house of any citizen, you have constructed such a project. The panel counsel appearing for the jail is requested, is instructed to secure information as to whether the units of the kind are established beside the houses of citizens anywhere in the country.
My lord, in fact, not a case of CNG station, but of underground pipelines. When in this court it was challenged. So it
the underlying pipeline, there are safety aspects vary.
Yes, my lord.
Yeah.
Similar safety regulations apply to these.
Let us.
Oblige me.
In the mean. Okay.
48 may be the last.
Number 48, there are number of cases. 11489 of 2025. After being noticed, I have entered appearance for the OP number 3 on 17th June 2025 loss. So I pray not for it to file my counter affidavit loss.
Before number 3. When notice was issued?
Notice was issued, my lords, on 1/5/2025, my lordships.
1/5, it was sought loss upon the OP number 3. Thereafter, on instruction, I paid on 17/6.
When you appeared is irrelevant to us. When notice is served is relevant because under your extant rules, chapter 11, only 1 week is granted for filing objections. Rules are not amended. Rules are rules.
I don't despise. I said because I have already obtained the Parvez comments, everything. I file my counter affidavit. That's why I'm seeking for time.
1 week will give.
But 2 weeks you may grant because
2 weeks too.
But before that, I have filed an IA, lordships.
IA for?
Initially,
IA
for say operation of annex IA by 2 millets. But initially, the petitioner has challenged has challenged the order wherein the prayer of the petitioner has been rejected. Prayer of the petitioner for rejection regulation has been rejected, despite containing 26 years of contractual service, lordships. And now, my lords, your lordship may kindly see on.
Are they discontinuing you?
No, they have gone, my lords. They have issued opposite party number 1 has issued letter to Odisha Staff Selection Commission to fill up those 4 posts against which I am continuing. Status quo is there. Despite that, also they have gone for advertisement, your lordships.
Interim order to continue. Counter to be filed within 2 weeks. Call after 6 weeks. Interim order to continue.
That IML, the stay operation of only that order. Interim order is done. Status quo is there. But why
not bring it here?
They've already issued letter, your lordship may kindly.
Even when there is status quo order, you have issued.
Yes, your lordship. Your lordship may kindly see 6/5/2025. Annexure IA by 2, your lordship may kindly see.
Learned counsel for the petitioner and why who appears?
I am appearing for OP number 2.
Who is 2?
The State Council for Technical Education.
Who has issued that notification?
Opposite party number 1, your lordship.
OP number 1. Who is OP number 1?
Government. Yes, your lordship. Yes.
Why
let me serve the copy. I've already served. No more. This is not. I have the. This is the Commissioner of Secretary. Officer is opposite party number 1, your lordship.
Counsel for the petitioner draws attention of the court to the interim order granted by coordinate bench. Coordinate bench of this court. Why the honor?
By order dated 1/5/2025.
1/5/2025. And he complains that despite this order, OP number 1 has issued notification.
Order dated 6/5/2025, which is annexed IA by 2, page number 9.
Order dated
6/5/2025
at annexure
IA by 2.
IA by 2
at page number 9.
Addressing the Secretary, Odisha Staff Selection Commission to initiate.
They are the recruiting agency for class 3.
To initiate recruitment process for 4 posts in question. First off, learned counsel says that this is a blatant violation of the court order, and therefore the violator should be hauled up for contempt. First off, ask them to request steps.
Let a copy be served today itself. I will come ready by the day after tomorrow, my lord. Let a copy be served, man.
I will direct his arrest and detention.
No, my lord. I have definite instruction. It should not be person. At any cost, it should not be that order is to be respected, my lord. If at any, let a copy be served today itself, my lord. In course of the day, I will come ready by tomorrow, my lord.
All this matter, Mr. Mohan, at the request of learned AGA Mohanty, this court threatened as to why the concerned officer should not be arrested and detained for violating the court order. First, at this stage, Mr. Mohanty seeks 1 day time to confer with the concerned officer and to examine whether the letter dated 6/5/2025 can be retraced. First, call tomorrow.
Let them serve right
Give
now.
copy. Give copy.
I can ask
direct,
this.
Mr. Mohanty, when there are court orders.
I'm conscious. Being officer of the court, I am conscious. That should not be. Otherwise, nobody will come to our rescue. I am conscious.
First contempt, second contempt, third contempt.
That became a...
What is this happening?
My lord, with all humiliation, we are also party to the proceeding. Not as a government, as a officers of this court also.
Orders means court orders. Obey the court order. If court jump from the
definitely, I'll come ready to explain the same.
No.
Today is a Monday, my lord. It is Tuesday or Thursday, day after, my lord.
Tell your officer.
Yes, ma'am.
Perhaps he may not know the nature of this court. Yeah. Call tomorrow. I have seen the third contempt coming before me. Unheard of. Unheard of. Yes. What is this? You have taken citizens for the... Why and we are responsible? We judges are responsible. All playing with the people's lives. Yes. Item 49.
49 has been listed by the registry for correction of the IN number wrongly mentioned in the order dated 1/8/2025.
1/8/25. What correction you need, brother?
But as it is revealed from the cause list, the number of the interim application has been wrongly reflected in the order.
What it should be?
It should be, my lord. It should be 12742 of 2025, but it has been wrongly typed as 12742.
Counsel for the petitioner points out the mistake committed by the registry in print, committed by this court in printing his IA number 12742 of 2025 as 12742 of 2024. First, register to rectify the same.
Typographical
Registry to rectify the same and issue a free copy of the order to the parties if applied for. Mistake of the court is regretted.
This is not a mistake of the court. Typographical error.
It's a typographical.
Courts are not above. We are not infallible. When 50 years of the Supreme Court was celebrated, Supreme Court published one commemorative volume. Do you know the name? Supreme, but not infallible. So beautifully titled. We are bound to commit mistakes, and we should own our mistakes. That's the first thing. Yes.
Item 50. This is, my lords, a very unique case, maybe the solitary case pending in the High Court. Execution of the orders of the Supreme Court under Order 45, Rule 15.
Order 45, Rule 15
of CPC, Civil Procedure Code.
Let us see the provision. From Order 21 to Rule 105.
That is execution. That is execution. This is the only order.
Good judgment.
This is the only order.
Read.
May I?
Read. It's a everyday learning process for judges. Perhaps for lawyers also.
May I?
Yes.
Whoever desires to obtain execution of any decree or order of the Supreme Court shall apply by petition accompanied by a certified copy of the decree passed or order made in an appeal and sought to be executed to the court from which the appeal of the Supreme Court has been preferred. Now, just a brief background.
What is meant by that?
That is, when the parties have agreed before the Supreme Court and a compromise decree is passed, number one. Number two,
it does not say compromise decree.
It does. It says decree and a compromise.
I want to know how Mullah has given a brief description of this provision.
Mullah says that decree can be a decree by contest or decree by compromise.
Correct. No difference.
No difference. This is an order passed by the Supreme Court on consent of both the parties. Now, what is the basic fact? It will be easier for you.
I have not understood the law. You have convinced me on the law. You have read the law.
Read it again? May I read it again?
Read it, but explain to me what it says.
It says when an order is passed by the Supreme Court, then the appeal which has gone to the Supreme Court from the court, an application under Order 45, Rule 15 can be maintained
in Supreme Court.
Yes.
From which these proceedings are
on the Supreme Court. So
in other words, for executing the decree of the court, Supreme Court, you need not go to Supreme Court. You can go to the court which passed the original proceeding.
Absolutely.
Makes sense also. Otherwise, asking man to go to
that's not necessary.
No. Except where suit is filed in the Supreme Court. So,
if suit is there,
that provision is also there under the Constitution.
Yes.
One of 1975.
Yes.
Karnataka, State of Karnataka versus Union of India.
Yes. Where there is an original side where the suit can be filed.
First time it has come.
This has come 100 times.
No, here it is.
Before your Lordship, yes, I will just read the last order. Lordship may kindly turn to order dated 28/9/2021.
28/9/21. Of coordinate bench.
Yes.
What does it say?
May I?
No. What does it say in brief?
It says that, because your Lordship has to understand the facts of the case.
Yes.
Before Godavaran came in 1994, there was no restriction in felling of trees.
Godavaran is not one case. It is a series of cases.
It starts from 94 and it's still going. This matter is of 1971 and I am the third generation fighting this litigation in the High Court. A and B had applied for an auction of forest coupe.
Understood.
A got the forest coupe.
It is by auction.
By auction. B challenged it in the High Court. B's writ application was allowed. A and state went to the Supreme Court.
Their compromise happened.
Where in the Supreme Court, state agreed that we will abide by and we will give where A and B mixed hand, the joint hand, and said we will equally give the forest coupe to them. And a compromise decree was also passed. Thereafter, Godavaran came. They filed an application for modification. That was dismissed. No, you have to stick by what the Supreme Court has passed. Either you financially pay them or you give them the woods. They did not do it. So what is the remedy left to me? The remedy is Order 45, Rule 15. I filed an application before this High Court to execute the order passed by the Honorable Supreme Court. And then this is the order which the High Court passed, that you now decide how you are going to compensate the petitioners who have been fighting the litigation since 71. And they have been repeatedly been asked how you are going to do, how you are going to do, how you are going to do. They have not come up with any
proposal.
Now, in my application, what is the amount of wood which I am entitled to get? Now, under the Odisha Forest Development Corporation, they are the state-run corporation. They have the right to cut the dead trees and put it to auction.
Before Godavaran.
Now also, they can yes. Odisha Forest Development Corporation, they have the right. They can only sell those. Either you give that amount of wood which is lying with the forest development,
or money in terms. So you are struggling to execute the.
I am struggling till date.
There is one judgment of the House of Lords, 1871-72. It is reported that is Apex Court in Rahul Shah versus some Gandhi.
The recent judgment.
2022, 23.
Rahul Shah says that execution has to be decided within 6 months. 1, 2, 3, 4 parameters have been given.
There they have referred to Raja. It was my judgment actually from Karnataka. I had referred to Raja of, I do not remember. No, not Raja of Manda, something like that it is. 1870, it is reported in LR 1871-72, where the Supreme Council said the difficulty of an Indian litigant begins after obtaining the decree.
And Lords, that was followed by Vivian Bose. Justice Vivian Bose said, the misery of a decree holder starts after he obtains the decree.
Who appears for the opposite party?
State.
Do you agree that there is a compromise decree at the hands of the apex court?
Yes.
And decrees to be obeyed? Do you agree? Now, if there is any impediment because of T.N. Godavarman jurisprudence.
Not only Godavarman, the area has been declared as sanctuary in 1993.
That is the alternative. You have to compensate now.
Yes, we have given offer. Your Lordship may see, we have filed an affidavit by opposite party number 2, that is annexure C/2, page 30, to take back there are two persons. Your Lordship kindly come to annexure C/2, page 30.
C/2 means whatever documents you produce along with your counter, that becomes C series.
Yes.
Counter C's, that way.
ABC, and 2 is the opposite party number.
Okay. What you have said? Page number?
Page number 13, internal page number 13.
13?
Yes.
In inviting reference to your application cited above, is to inform you that has been taken as per the instructions of so you are requested to please
security deposit.
Get back your security deposit. How that will be compensatory?
Correct.
Compensatory means it is not for money which he had paid.
Then he has already taken the logs which trees were failed.
The logs he has taken?
Yes.
Where is that? Show. If you have taken, why are you refunding that money?
Correct. That is the balance he has to take. The balance.
Now, what was the total amount of he has deposited, and what is the refund you are asking him to take back?
Yes. Your Lordship may kindly, matter was before your Lordship coordinate bench on 14/7. 14/7, and the coordinate bench directed to file affidavit on behalf of the opposite party number 3, the principal conservator forest. Just now I got the instruction from the opposite party. Just now, that has
instruction means affidavit is not necessary.
No, affidavit you will file. Just now I got the instruction over.
File it today. Tomorrow I am calling this matter. How long he should fight in the court? And he will go on advertising to everybody that don't believe the court at all, because I am suffering like this. What will happen to the faith of the people in the judiciary?
71.
Yes.
Tomorrow I am calling.
You let me call it the day after tomorrow.
Yeah.
Because he is to come from current.
The request of EGA reluctantly adjourned to a day after. Call on Wednesday.
Grateful.
You just see how various commentators have written about this. This is the first time I am coming across. But it makes abundant sense. That asking a poor citizen to go to Supreme Court to get everything executed. That may be the policy. There is one article, there is one provision, Order 21, Rule 25, 26, just see.
Order 21?
Order 21.
Rule 35.
24, 25. I vaguely remember. Don't much rely upon my memory. I myself, I am not relying upon my memory. nowadays.
process for execution, where the preliminary measures required by the foregoing rules have been taken, the court shall...
There is one. All courts should function in aid of Supreme Court orders. There is one article, na? Order 21 rule 20 process of every such person for endorsement of process 25 20 court mistake 26 liability order for positive mistake of execution before payment of money. There is one provision in CPC.
I will find out.
Just see that. It's after a recommendation of Justice V.S. Malimat's 76th amendment. They have made that provision.
I will write. I will assist the court.
Every court authority's person shall act in aid of the orders.
I will assist your lordship.
Yes.
I will assist.
Yeah. Thank you for enriching me that knowledge. Yes.
Item 51.
I will also go through. Ask our librarian to keep that order 45.
Order 45, rule 15.
Rule 15. Yes. Any latest judgment of the apex court on that? Do you have? How courts have treated it?
In fact, execution Rahul Shah, after Rahul Shah in 2025.
Rahul Shah did not refer to this.
No.
No.
I will find out.
Okay. Yes.
Item 51.
Wait, please, madam.
Yes, brother.
Lordship, this is my application with regard to the appointment of a Shiksha Sahayak, Lordship.
This is post-admission matter.
Yes, madam.
After notice.
It was had at length and the direction was given to the state to obtain instruction whether there is any vacancy or not, Lordship.
Can we come after eating lunch?
Yes.
Fine. Done. He has to come, otherwise I cannot go even if Cobra comes at my feet, he has to come. Yes.
Item 35.
Petitioner school is a purely private management school. The district education officer is the head of the management. What happened while the petitioner is working as an assistant teacher in the said school opposite part number 4, the headmaster of the school has been resigned from the said school. So vacancy arose. Since he is the senior most teacher, he should be the headmaster in charge of that school. But the management give to the second persons to the headmaster of that school.
So is it a government school?
No, my lord, purely private management schools.
Private management.
Private management.
But how reputation is maintained?
So that since the district education officer is the controlling authority of the said school, so he made a recommendations to the district education officer.
Let him consider.
Sir, district education officers made an inquiry under annexer through block education officer through annexer 7, and he found that he is the senior most teacher. He should be headmaster in charge. And under annexer 8, page 18, the district education directed the opposite note 4 to give headmaster in charge of the said schools. So from the date of my inquiry, the opposite number 4 did not allow the petitioner to perform this in the attendance register and not allowed to perform the duty also. So he approached again in spite of annexer 8, page 18, since the opposite number 4 not allowed the present petitioner to perform his duty, he approached this honorable court and Honorable Court directed.
You take notice.
Sir,
That's all.
Sir, I am submitting. Sir, I am submitting. Sir, what happens, sir, in the present scenario?
Why can't you?
Sir, Annex 10. Sir, Annex 10. My representation has been considered and passed necessary orders.
Issue notice. Learned the
2, 3, sir.
what?
Sir, Annex 10 does it kindly, sir, sorry. Sir, Annex 10 kindly.
No stay, nothing.
No, sir, Annex 10 kindly peruse, sir. They are not allowed to sign the attendance register. So the headmaster in charge of the schools file another case, double PC number, and in that case, this Honorable Court passed interim order. I filed one modification of that interim order, and in that modification of interim order, Annex 11, this court observed that while however, it is observed that page 23.
Where is your friend? Petitioner.
I am the petitioner.
You are the petitioner.
Petitioner, sir.
You want modification of?
Sir, the headmaster in charge, after disposal of my representation under Annex 10, in pursuant to the direction of this Honorable Court, page 22, pursuant to order dated 21 passed by this Honorable Court, as well as the representation of the petitioner had Annex 10 of the writ petition, this opposite party considered and instructed the headmaster in charge of the concerned school to allow CCI, this is the petitioner in this present writ petition, to perform as headmaster in charge as he is the senior most teacher of the said school.
He is
but
not allowing.
Not allowing to this said school. So without allowing, he approached this Honorable Court in another writ petition, that is WBC number 27149 of 2024, Annex 11, page 23. And this one, sir?
Write down that number, I'll call.
Sir, Annex 11, page 23. Sir, in that case, this Honorable Court has passed interim order that status quo of the petitioner as well as opposite party number 4 is maintained till the next date. Brother, so I filed a modification order.
Brother Satapathi's order.
Sir, modification of that order. Modification, this Honorable Court on 1/8/2025 ordered that para 6. However, it is observed that if the authorities are not allowing opposite party number 4 to discharge his duty, it is open for the said opposite party to file appropriate application in that regard. This is the
application.
I filed this application. But to allow, because district education officer already granted me to act as an headmaster, but he has not obeying the order and not allowing. This is the only fact, only to allow the
who appears for the opposite party. AC.
AC. District education officer or AC? Only direction we give to the AC to allow to the petitioner to perform duty.
There is an order with a higher appoint. You don't want to implement the, headmaster does not want to implement that order.
Yes, my lord. I will take interest, my lord. Mr. Mahanti is appearing in this case. So the
Friday?
He is appearing, my lord. Friday. Yes, my lord.
Why he is not being allowed, even when there is an order?
Yes, my lord.
All this matter on Friday. At the request of the AS. Have you given copy of the application?
Yes, ma'am. In the meantime, take instruction why.
That's for conferring with the jurisdictional officials and come back. Item 51. Yes.
Please, my lord. This is an application relating to appointment of Shiksha Sahayak Lordship, Junior Teacher Schematic Lordship, wherein the petitioner has prayed for that the opposite party number 6 and 7 who have secured lesser marks than the present petition, they have been appended. But the present petitioner's appointment was not at all considered, for which this application has been filed, Lordship. Kindly have a glance to the order dated 26th of March, Lordship.
26/3.
26/3, Lordship.
What is there? You take instruction and come back.
Yes, Lordship. There are some vacancies in that Ganjam district, Lordship. So, Learned Counsel for the State was directed to take instruction on the last 2 occasions, whether there is any vacancy or not, Lordship.
Why have you appointed the less meritorious candidate when meritorious candidates are available?
Because of her fault.
Fault?
Yes. Replace the entire case with case before the lordship.
Yes, objection is filed.
Yes.
Yes.
We have filed a detailed count.
I am appealing for the OP number 6 also.
OP number 6.
6 and 7.
I am appointed as a regularist.
Huh?
And 7.
7. Who are said to have secured less marks than him.
Sir, application is to be.
No, that's what
He is saying.
Not true.
Saying, let him compute.
Yes, my lord. Lordship, at the outset, an advertisement
Now
was.
10 years are over.
Yes, my lord.
Then if you displace them, where should they go?
That is why this honorable court has directed to take instruction whether some vacancies are not. To my instruction, there are 2 vacancies are there, lordship. I have also placed before this honorable court, by virtue of which the order dated 26th of March 2025 was also dictated. And thereafter, 2 occasions were there where the learned counsel for state did not place before this honorable court whether there is any vacancy or not. To my instruction, there are 2 vacancies are there.
You have said it twice now. You have made them.
Yes, my lord. So my this is an application of the year lordship 2015, my lord.
Now what is your age?
43, lordship.
43. Time barred. But matter is pending here.
Yes, ma'am.
That's the only case. Your first ground is you are more meritorious than other private respondents.
Yes, ma'am.
Your case is not considered. Their case is favored.
Yes, my lord.
That is first ground. Other ground is
what happened, lordship? An advertisement was there. I have applied for in pursuance to that advertisement. My result was declared on 8th of August 2000. I'm placing the date set, lordship.
How much you have secured? What is the percentage of marks you have secured?
71.68, lordship.
71.68%,
my lord.
In what examination?
IGNOU, Indira Gandhi National Open University GED exam, lordship.
That's at degree level?
Yes, my lord.
Degree level?
Yes, ma'am.
Okay. And their score is? What is their score?
My score is, lordship, 173.57. Their score, opposite party number 6 is 173.355 and 7 is 170.3, lordship. Page number 6, paragraph 7, my lord.
Page number 6, paragraph. Petitioner score is?
173.57, my lord. 5708.
And R6 and 7 are there?
6 is 173.355. 173.355.
R7?
173.3, my lord. 173.3.
So you are more meritorious, is your version.
Yes, ma'am.
And any other compliance was there?
Yes, ma'am.
Production of certificates, etc.
Everything is only their contention is that before the last date of application, I have not received my certificate, but the result was declared and the provisional certificate was also there. So their contention is that I have not obtained my before the last date of appointment. I did not obtain my provisional certificate, but I obtained it before the verification, lordship.
Subsequently, you obtained.
Yes, lordship.
Before, but it should be before a particular date.
Yes, lordship. But when the document was verified, before that I obtained my certificate, lordship.
No, question is, your certificates to be produced as on the date of verification or as on the date of the cutoff application?
As the date of verification, lordship.
Is it?
Yes, ma'am.
Where is that shown?
Lordship, page number 18, lordship.
18.
18, lordship.
Which paragraph?
That is, lordship, Clause B, Lordship.
Huh?
Page 18, Clause B, Lordship. Of my application. Yes, my lord. One small B is there.
In case of candidates and qualification, B is the person. No,
that is a mode of calculation, Lordship. And subsequently, at page number 19, column number 5, my lord. Page 19, column 5, Lordship.
Mode of application.
Yes, my lord. Application will be submitted through online. A candidate may make an application in any revenue district of the state.
Right. But which is the cutoff date for production of the documents?
It was, Lordship, it was extended by subsequent advertisement, Lordship, that is 13th of October 2013, my lord.
25/10/2013,
Lordship.
2013 is the last date.
It was the last date of objection, Lordship.
For objection?
Yes, my lord.
For production of documents?
That was 13/9/2013, last date of application, Lordship. 13th of September 2013.
It's just a document.
13/9/2013,
Lordship.
You produced the copies when?
27th of September, my lord.
Then it is time barred.
No, my lord. That was for application. 13th of September was for the last date of application. I applied, my result was declared.
When your document should be produced, you are not answering that point. When the last date for production of document, when you produce this. Anybody can say that, no? It's a question of record. Yes.
Annexure 2.
Annexure 2.
That is in vernacular.
30th August.
Yes, August 2013 is the last date of submission of application.
38.
30, Lordship.
308. You produced it on which date? Subsequent. What can be done? That too 10 years have lapsed now. Perhaps they have married, they have built houses. So if we send them back, where will they go? They have to go to Chor Bazaar for living.
Lordship, what happened in my case is that I have passed out the degree on 8th of August.
Correct.
8th of August, I have passed the BD degree.
Yes.
In pursuance to the result declared through online portal, I filled up the application form. And subsequently, I was also selected. And the document was verified. At the time of verification of document, the last date was there, but subsequently I filed my provisional certificate. But their concern is that whether I have passed before the last date or not, because the result was declared on 8th of August. They are saying that you have not obtained the provisional certificate before the last date, that is on 13th of September 2000. Lordship.
The production of documents. Is there any prescription? All documents should be produced on or before. Is there requirement? Generally in the recruitment notice.
That is 27th of September, Lordship.
27th of September. So many dates you have confused me with.
Sorry, my lord. Annexure 3.
Anybody will tell the government advocate what is the grievance now? Let us. But he is a meritorious candidate, is not much in dispute. Number one.
It is.
Number two, the last date for filing of application is 30 August.
Yes.
He passed on 8/8.
He said, but he didn't produce the certificate. So his candidate, her candidature was rejected. And in fact, she has produced the certificate in 2014. 5th February 2014.
By that everything was what we had got.
Obtained under RTI, then she produced.
What can be done? Can she be accommodated in any of the vacancies without disturbing?
The last, the coordinated bench of this Hon'Ble Court.
Last time for information.
Now, you Lordship may kindly come to the paragraph 6. Sorry, paragraph 6 of my counter, internal page 3.
Saying
that the recruitment process 2013-14 was over. Vis-a-vis all the posts under URW category of TGT arts were filled up. My learned friend was agitating one that there are some posts. That is under the schematic provision. That is for junior assistant. That was in terms of the resolution of the government made in 2023. That is
Can you consider under that? Anyway, he's here. Meritorious candidate also. More meritorious than them. Although he did not produce, there is fault. You are right in pointing out. There is fault on his part. Okay, no issue. But how to send a meritorious candidate back without a small fruit at hand?
The scheme under she has applied, that is over. It's a new scheme. That
new scheme has
some vacancy.
In that new scheme, consider the candidate. Can you?
Because
there will be other
legal complications, maybe.
Other competitors will be there. And you give age relaxation. Let her compete.
Age relaxation.
Age relaxation. Because she has been fighting the legal battle.
Yes.
Give legal. Brother, will you be happy with that? If age relaxation is given, more than that, nothing can be given to you. If you agree, you file a memo. I will tell them, give age relaxation because she has been fighting the legal battle, being more meritorious. Otherwise, I have to dismiss the petition on the ground, very technical ground, that you did not produce the requisite document till 25 February 2014, when cutoff date was 30 August 2000.
No, Lordship, before that cutoff date, I have produced everything, Lordship.
What all you have produced?
Yes, Lordship, on 27th of September, I have
27th of September is after 38 2013. September in any calendar will come after August only.
Lordship, may I request
unless you have some other calendar.
Come tomorrow, Lordship.
That's the only relief. That too, I have to do lot of circus to get that relief also. That's the best way. You apply under the new scheme and you will be given age relaxation, but you will be competing with the rest of the people.
I'll take instruction, Lordship, only one day. Tomorrow, Lordship.
No, nothing like this. This is a concession. Not even an order. On order, you have no case at all. He will simply say, those vacancies are over, that recruitment process has come to an end, we are helpless. Even if you say this and if I make an order, that may be put in challenge. But I want to take that risk because I will not be a party in the appeal. You will be.
Lordship, what I am trying to submit that before the date of verification of the documents.
It's not verification of document. Application should be complete as on the date you make the application. Every recruitment process will have that clause.
Lordship, may I draw your kind attention to the judgment of Honorable Apex Court, Lordship?
No, not Apex Court. Notification.
No, not regarding that when the application was supposed to be closed on the last.
AGA, kindly be seated. I have to go convince him after arguing. I need more time to argue.
Before the last date of the application, I have availed my qualification, Lordship.
You obtained it on 13/8.
No,
you said the date.
8th of August, Lordship.
8/8,
Lordship.
But you have produced the certificate long after the cutoff date.
No, not long after the cutoff, before the date of verification, Lordship.
No, before
at the time of
verification date.
Lordship.
Verification date is one thing. Cutoff date for making application along with all the documents is another.
Yes, at that time I have also submitted, Lordship. At that time, when the documents were verified, I have submitted my provisional certificate, Lordship.
Where is that? You produced it on which date?
Lordship, obtained on 20th September and filed it on 27th September, Lordship.
38 was the cutoff date.
No, Lordship. That was online application that ever. Online application was closed by that date. I have submitted online application on 30th of August.
Correct.
But the verification of document was supposed to be closed by the end of September, Lordship.
You are not answering my point. When you were required to, when the candidates were required to produce the document?
On the date of verification, Lordship.
On the date of verification, it will not be like that. Let us read the recruitment notification. Problem with your bar members is no notes at all when the application was invited. What is the date of last date, cutoff date for applying? When application was made? When I obtained the degree? When I secured the documents vouching my graduation? No system at all. The farmers plow their field better than we people. They do systematically. Nobody is holding a small chit in his hand and arguing before me. You read and come back. I'll give you short accommodation. Okay? Make small note. How note should be made in Learning the Law by Glanville Williams. He has given how brief should be prepared. Small book, about less than 250 pages, 247 pages perhaps. He has given to argue what all to be prepared, how to make argument. All right? You have to show that book next time. That you should show the book. You should show that you have read the book. On that condition, I'm giving you a small book. It is by Glanville Williams, or Learning the Law. All right. Call week after next to enable counsel for the petitioner to prepare more and come back. Prepare adequately and come back. Okay. Next time you have to show that book to me. Which book?
Learning the Law.
Huh?
Learning the Law, Glanville Williams.
Glanville Williams. Okay.
Item 52.
52, my lord, on behalf of Mr. N. Linka, I pray for an adjournment.
Not ready?
No, madam.
Doctor, you have to seek adjournment, you have to say few words. Then adjournment. Otherwise, bar will not improve at all. It remains as it is. You will become qualified clerks to carry the backs of the seniors. That's not the object of your staying at the bar.
My lord, here we challenge the...
What order you are challenging? What is your prayer?
Annexure 7, my lord.
Annexure 7 is prayer. It cannot be.
And here we challenge the order that...
Prayer is at page 20.
Cancellation of caste certificate.
Caste certificate. For that, generally, writ of certiorari is quashed or sought for, not mandamus. Is it not? Passing of. There is a writ of mandamus, there is writ of certiorari. Okay? Writ of prohibition, writ of habeas corpus, writ of justification. Is it not?
Yes.
There were 208 writs in English law. But we have made it limited in the nature of. What's the point?
Yes.
You read that and come back.
Yes, ma'am.
Dr. Ambedkar's speech is there in Constituent Assembly when Articles 227, 228, Article 32. When discussion was taking place, our people wanted English law of it should be made applicable to us. But Dr. Ambedkar and Justice Alladi Krishna Swami and Benagal Narsinga Rao, they said, our people are not English people. They are not that good in English. Therefore, local modification is necessary. Need that go to that debate, Constituent Assembly debate. Next time you have to answer.
Yes, my lord.
When do you?
Come prepared.
When do you?
End it at next week.
Next week, then that you will complete the Constituent Assembly debates. Yes, call week after next at the request of arguing counsel for the petition. Yes.
Interim
order is there.
Yes, madam.
Interim order to sentence you can heard Miss so-and-so who argued well. First off, she seeks a continuation of the interim order. First off, the case is made out for continuation and therefore interim order is continued till next date of hearing. Call after 4 weeks is up.
Oh, yes.
Item 53. Yes.
Here, Your Lordship, can I have a glance to order dated 8/7/2025 and 16/11/2023.
8/7/25.
Yes.
Hybrid mode heard requested. That order has no meaning. Next to another order. 16/11/23. Taken up hybrid mode. Heard counsel. Issue notice. Ishwar Mohanty. 3 extra copies. Counter affidavit. 6 weeks. And the list is first year of February 24. So we are in August 25. Then any order 8/7/25. Requested the list to be filed before next date. This is like first contempt, second contempt, third contempt only. No positive order. Any other order?
No.
These are the orders.
Here I am, my prayer before Your Lordship that
page
12. I pray for passing of the order rejecting my representation under Annex 2.
From contractual appointment to regular appointment.
Yes, Your Lord.
On what basis?
Because the advertisement was issued for filling of the post on regular basis. As against that advertisement, with the 3 petitioners submitted our application, participated in the selection process.
Selection process was what?
Selection process, my lord, for written examination and computer skill test.
It happened.
My lord?
That happened.
Yes. And in the interim, there was an addendum to the original advertisement.
Saying
that some post is to be filled up on contractual basis. But our application was against the first advertisement, which was for regular appointment. That is why I take Your Lordship to first Annex 2, page 20.
How many posts were there?
My lord, 16 and here it is 13, totally 29. 16 in Revenue Administration District Cadre and Joint Commissioner Taxes Jajpur and Jajpur Road, that is 13. Page 20.
Who appears for the opposite parties? When they have faced the interview, wrote the test, qualified, selected, appointed. Why contractual?
Yeah, initially the advertisement was issued for regular.
Pursuant to that, they applied.
Yes, apply. Then second, the addendum was issued to that advertisement, and it was made clear that those who have applied pursuant to the earlier advertisement, their cases will also be considered. But for contractual appointment.
No, having issued it for regular recruitment.
Yes.
How can you all of a sudden convert it into contractual? Which is the power? Where is the power?
That is the case,
It may be all right. We are not a Mughal government. We are not the East India Company. Where is the power to metamorphose the regular recruitment into contractual recruitment? Which rule authorizes? Who is that Mughal? I want to know.
I will counter, because again the final order.
No time wasting. How many times the other brother judges have given time to you? No time will be given. I will take the writ petition with face value. At least in 12 matters, if I do that, government which is in the slumber will wake up. It may wake up, I do not know. It may be Kumbhakarna also.
Why they have done this, that is not in the order while rejecting the representation. For that,
they are simply telling ours is in a regular recruitment process.
Yes.
We are the horses who ran in the race. We are not Tangawala horse. We are race horse. But your officer wants to call them as a Tangawala horse. That they are not agreeable.
Page 16.
And you want to know where is the power to convert regular recruitment into contractual. That power, if it is not there, is not there.
The authority who has invited the advertisement, issued advertisement, that authority
is power. He has power to issue advertisement calling for recruitment. I fully agreed. But metamorphosing it into lesser one, that is not permissible. Therefore, I say ours is not East India Company. You can't do what all Robert Clive wanted to do. You have to do on normative basis.
And another small thing I want to bring your lordships another. At previous occasion, I approached this honorable court because at that time representation was pending. Consider representation, and my representation was to be considered in accordance with the judgment of this honorable court, which I have also annexed here, which says that once there was an advertisement and selection process and preparation of merit list, they cannot make appointments, some to regular post and some other to contractual post. That is what the page 32 is there. And this honorable court has placed reliance on the 1997 Supreme Court in case of Syed Yasuddin Ahmad.
Sit down.
Right.
Please be seated. Petitioners have scripted their prayer as under. First, regardless of the text of the prayer, their essential grievance appears to be the metamorphosing of regular recruitment into one of contractual. And learned counsel appearing for the petitioner finds fault with them with that on the ground that the recruitment process is normative in as much as it has been undertaken under the extant rules. Semicolon. Once the recruitment process begins with the issuance of the call notification, till it is accomplished by selection followed by appointment, its nature cannot be changed. In the absence of contract enablement. First, next paragraph. Learned AGA for filing counter again sought for time. However, request is rejected in as much as the opportunities given earlier have not been utilized. A citizen knocking at the doors of court cannot be asked to wait for a blue moon for filing of objections by the state at its sweet will, ours being a constitutional governance, the Mughal era having ended long ago. First, be that as it. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter for the following reasons. Number one, the recruitment process began for appointment of junior clerks. Wide notification number 574 dated 28/2/2011, a copy whereof avails at Annex 2. 7. The total number of courts were 29 initially. First up, petitioners had applied pursuant to said notification. 7. They wrote the examination and they faced the interview. First up, they have also been issued the appointment orders. First up, however, it is contractual in character, which they are not happy with, justifiable. First one. Next paragraph. Learned AGA appearing for the OPs vehemently contends that the authority who had issued the recruitment notification had issued addendum dated. What is the date of the addendum?
23/3/2011.
Sit down. This is not a primary school. You have to sit down and answer. Dated
23/3/2011.
23/3/2011.
Just one more something.
Adding some more vacancies and providing for conversion of the nature of the recruitment process from the regular to contractual. First off, when asked as to which rule from the statute book gives that power, learned AGA is not in a position to lay his hands on any such rule or ruling. First off. Conversely, learned counsel appearing for the petitioner presses into service the apex court decision
1997,
name of the case, then report.
(1997) SCC page 24, parties government of AP versus Syed, that is reflected in page 36, Syed Yasuddin Ahmad.
Yes, just a minute. That decision also adumbrates the submission of learned counsel. First. Next paragraph. Learned counsel for the petitioner draws attention of the court to the earlier round of legal battle in WP number.
WP number, my lord. 26847 of 2021. The
26814 of 2021.
26847.
847 of 2021.
Order dated 13/9/2021.
Disposed of by a coordinate bench of this court by order dated 13/9/2021.
Right.
With a direction to consider petitioner's grievance as aired in the subject representation in the light of another coordinate bench decision in Saroj Kanta Mohapatra versus State of Odisha 2019 1 OLR 1006. First up. This representation having been considered came to be negatived.
Yes.
Wide order dated?
Order dated 26/9/2023.
26/9/2023, which is impugned in this case. Correct?
Yes.
Which is impugned in
yes, sir.
petition. First one, obviously, the consideration lacks legal approach and it does not address the nuances involved in the light of the decision cited, and therefore rejection cannot be sustained. First, in the above circumstances, this petition succeeds. A writ of certiorari issues quashing the impugned order dated
26/9/2023.
Coupled with a direct writ of mandamus to the OPs. Which OP?
My lord, that is OP number.
So and so. To treat the petitioners
OP
as
3.
OP3 as having been the regular recruitees ab inceptio and grant all consequential benefits flowing therefrom within a period of 8 weeks. First order. Default or delay shall be viewed very seriously at the next level of the legal battle, if at all petition is driven to first order. No. Order. Yeah, there is one special notice matter. Let's move that. Yes, brother.
Lordship, in fact,
You have moved it.
No, I will have to Lordship for my friend Lordship because
What is the admission? The urgency, brother?
Lordship, urgency, two people are going to give appointment to others, Lordship. Because why Lordship, the law is well settled, Lordship. One set of temporary employees cannot be replaced by other set of.
When the order was made.
Lordship, kindly see, Lordship, kindly come to
prayer columns. Come to prayer column, page 9.
Lordship. Lordship.
Our record has in
You have not served the copy.
Our records from the office has
not come. Another extra copy I am giving Lordship. Lordship, stated come to Annexure 4 for a moment, Lordship. On 18/7/24, I get this appointment, Lordship. 18/7/2024. Lordship, kindly see the language, Lordship, that we used in my appointment 24.
I saw it. I believe you. We need not go to language.
Lordship,
let us see the law.
Lordship, my fault is, Lordship, on page 25, on 23rd and 24, I prayed for regulation of my service, Lordship. That is my fault, Lordship. Then, Lordship, immediately they come up with Annexure 6. On 26/4, they disengage me, Lordship. Lordship, kindly see the very next page
26/4/25.
Lordship.
You had filed the writ petition when?
Lordship, today, Lordship, just I'm filing, Lordship. But, Lordship, kindly accept Annexure 7.
No, you have to give some respect to quote the question also.
Grateful, Lordship. Sorry, I'm extremely sorry, Lordship. I committed mistake, Lordship.
You were issued an order dated 26/4/25.
25, Lordship.
That was little less than 4 months.
Grateful, Lordship.
Why you did not?
Because, Lordship, my impression was, Lordship, it was a decision by the management not to appoint anybody, Lordship. But they came up with page 27, Annexure 6, Lordship. Annexure 7, Lordship, kindly come to page 28. Again, they floated, Lordship, advertisement for working interrupt, Lordship. Now they have taken a decision to appoint the same post, Lordship, by another contractual employee. That is the law involved in the case, Lordship. I cannot be removed, Lordship, when you are going to give appointment another set of contractual employees. Lordship, I should not be removed without any cause, Lordship, giving me reasonable opportunity hearing. Lordship, kindly see my career.
One second.
Lordship.
Another notice is dated?
Lordship, that is, Lordship, by they have given us 6/8/2025, they have given, Lordship, 11:30 AM. It appears in the mid of the advertisement. To be held on 6/8/2025, Lordship.
On 6/8 it happened?
Happened, Lordship. And now today, Lordship, perhaps they are going to a press, Lordship. And my career is first class, Lordship. I am a gold medalist, Lordship. And my still my experience From the day one, I am working in different colleges, having experience, they are going to replace me by giving a fresher lordship. That's why lordship occasion come to oppose lordship for kind intervention.
Issue emergent notice. What is the entry model you have got for?
Let's at least this give lordship that is act upon this advertisement, at least lordship. They have already removed me lordship.
Learned counsel for the issue emergent notice. Learned ASC is requested to accept notice for the respondents.
Okay, 1 and 2.
Office 1 and 2. Others are?
College that college would notice to go.
Notice to go to other respondents. Next paragraph. Learned counsel for the petitioner presses for interim relief, contending that his client happens to be a gold medalist and most meritorious, and that he had been working with the institution with effect from 18/7/2024, and he came to be disengaged in April 2025 under the impression that the institution was going for regular recruitment, whereas it is not. First off, in support of this, he draws attention of the court to what is that notice of recruitment?
Lordship, it is again walk-in interview for contractual.
Walk-in interview notice dated.
Lordship, that date is lordship, but see.
Interview date is 18.
27/7 lordship.
27/7/2025.
Scheduled to be held on 6/8/2025.
6/8/2020. 6/8/2025.
Date of
interview date. And that such interview having happened, anytime the appointment orders would be issued to make contractual appointment again. First off, he submits that. He adds that the apex court in a curtain of decisions has observed one set of employees cannot be substituted by another set of similar nature employment. First of all, there is some force in this submission, and therefore a case is made up for issuance of interim relief as entered. Next paragraph. Till the next date of hearing, no appointment orders shall be issued to any candidate in respect of the position or post to which petitioner was engaged as mentioned above, till next date of hearing. The post copy to be acted upon.
Grateful, lordship.
Yes.
Lordship, may appointment, lordship, oblique engagement, lordship.
I have said that.
Grateful.
Overhearing your discussion.
Lordship, sorry.
Is very good in legal language and submission. Yes.
Grateful, lordship. Item 54.
Yeah.
In this case, my lord, I am challenging the order of my rejection. My claim was that at present I am working and discharging my duties as a lecturer in logic and philosophy, my lord. In Sonpur,
you are a philosophy lecturer,
my lord, in Sonpur Degree College, my lord.
Yes.
In this present case, my grievance is before I was appointed and selected by the state selection board, my lord, I had discharged my duties in two institutions.
Aided or unaided?
One is aided and another is, my lord, government institution. So far as the first period is concerned, that is from 95 to 2005, my lord.
Can you give the date instead of year?
Yes, my lord. I have noted that. My lord, from 6/6/95 to 18/12/2005.
2005.
2005, my lord.
That is government or aided?
That is aided college, my lord.
Private college.
Private aided.
Yes.
Question of aid arises only in private college.
I am appearing for OP5, my lord, the principal, the college which is in question, my lord.
Yeah.
That period, my lord, when he was appointed,
Completed his documented.
my lord.
Let him complete. I'll hear you also. Will not pass any order without hearing.
No.
Yes.
So, my lord,
But then the
period,
second, in government, from what period?
that is from 1912-2005 to 7-10-2016, my lord. As a Sikhya Sahayak. And in the meantime, I was also regularized, my lord. While I was continuing as such,
You were regularized on which date?
on completion of 6 years, my lord, that is from 2011. The exact date I have not given, my lord, but admittedly, on completion.
Admitted, I am challenging it.
Yes, my lord. I have filed the service.
You have two opponents now.
Yes, yes.
Perhaps three, because one per person is there.
My lord, my lord. Yes, my lord. As order dated, I was regularized as per order dated 26-2012.
In June 2012, with effect from
Yes, ma'am.
same day.
Same date. And I was allowed the regular scale of pay. While I was continuing as such, my lord, I was selected by the state selection board, and under Annexure 6, I was appointed as a lecturer as Logic and Philosophy in Sonpur Degree College, my lord. Your lordship may kindly come to page. Sorry, Annexure.
Wait, appointment order dated?
Appointment order dated, my lord, 4-10-2016.
As a lecturer or professor?
Lecturer.
Lecturer in logic and philosophy.
My lord. And on the very next day, sorry, on 7-10-2016, I joined the post in that college, my lord.
410 is appointment order.
My lord? Oh, yes, that is the appointment order.
Now, what's your grievance?
My grievance is, my lord, since
That period to be counted.
Yes, my lord. With regard to the pension, my lord, the rule says under the Orissa aided educational institutions, the Orissa aided educational institutions employees retirement benefit rule 1981.
Read the rule.
My lord. Rule 6.1, my lord. In computing the length of qualifying service of an employee retiring on or after the first day of April 1982, all previous services except those rendered prior to his attaining the age of 18 years, whether temporary, officiating, or permanent, either one or more recognized education institutions, shall subject to the conditions specified in sub-rule 2, 3, 4, and 5 be taken into account for the purpose of retirement benefit under these rules.
What are the conditions? Sub-rule 2.
Yes, ma'am. The rule 2 says the definition and the definition in
We
this.
say the subject to.
Miller. I'm coming to the rule 3, Miller.
Rule 3.
Page is 881. 881. Application of the rules. These rules shall apply to the teaching and non-teaching staff of all.
Everybody.
Miller?
To everyone of your kind.
Miller. And Miller, there is a 3A. Lord's mechanic. Page 881.
Have they rejected that claim
Yes,
now?
yes.
On what ground they have rejected?
They are saying that, Miller, two grounds. My claim was the Miller.
Ground they have. I want
They have taken, Miller.
that is in challenge, na?
Because 2 institutions I have served. So far as the period from 2005 to 16, Miller, they have taken into consideration.
Private aided they are not.
No, Miller.
On what ground? Gap between entry and this one is long or one?
On the ground there, only ground they have, two grounds they have taken. Is the institution at the point when I was continuing there, that was not added one.
Whether rule requires any? No, nothing like that. Any institution.
But subsequently in the year 2016, they amended the rule and they substituted the rule and said that any added education institution.
But so far sorry, one sentence you have completed. You have used the word substituted. It's a legal concept, not an ordinary English word. Substituted means the House of Lords said with retrospective effect.
Yes, ma'am.
So that rule will be from the perspective itself.
That is my claim. And
now I have answered that you cannot claim that.
My lord,
the word substituted,
my lord,
G.P. Singh mentions in his statutory interpretation, where amendment is by way of substitution, it is from the first day of the statute book, unless otherwise indicated.
Lords, may kindly come to that amendment provision.
Yes.
Page 41.
41. Go to 41.
This rule may be called as Orissa.
All right, that's the nomenclature. Go to next point.
My lord. This is the
in computing the
length of qualifying services of an employee retiring on or after first day of April 1982
from an aided educational
institution shall all previous services rendered both in one or more than one aided education institutions as well as in the government establishment, except those rendered prior to his attaining the age of 18 years. Whether
that's not right. It means except aided the institution,
only that
everything remains intact. But the word used is substituted. Maxwell on interpretation of statute says where amendment is by substitution, it is with retrospective. Contra. That's the case. You can go on arguing till cows come back.
No.
That's another thing. But law is like this.
So this is the only two grounds. This is the one ground and the another ground.
One is sufficient.
Yes, no. Another ground, the records are not with the institution. But now at this stage, the institution where I was continuing, that is Amorjyoti College, Kutumla. At this stage, it is an added education institution.
You have said that.
Madam?
You have said that.
Yes, madam.
The service rendered by an employee in a previous institution which is aided shall be counted is the law. And that is the law with retrospective effect. Because amendment is with retrospective effect. There is no indication to the contra. G.P. Singh gives 3 judgments of the apex court where contra is inferred. But within that parameter, this rule is not fitting. You have brought it to my notice. But you will say whatever you have said is correct, that's my argument.
Despite my lord's opportunity, my lord, we are not able to file counter.
No, you will not still that is known to us. Everybody knows that you will not file the counter. But anyway, it's a question of interpretation of statute.
My lord.
Even that, from that angle also, there is no contribution from government side. No book is referred. No expert's opinion is tendered. No standard authors are quoted. Sterile bar, like desert. Only difference is whether one can argue whether it is Sahara desert or desert. The only thing has to be seen. With that argument you can make. Why that desert mentality in the bar? Why can't you sit and read what other business you have got except eating rasgulla? What has happened to the bar? How the state is going to, if bar is not good, how the state is going to improve? You will not have good judgments. You will not have good judges. You will not have good lawyers because you don't have any. You have to bring judges from other state. Hereafter, you bring judges from other countries. That helps you. They're coming. There is a policy being considered by the Bar Council of India. Where will you go? Where are the lands for cultivation? Nobody brings the chit. Nobody cites the decision. Nobody is up to date. And your clients are seeing you. That judge is scolding the bar. The market will be seeing you. How are you going to get the briefs? You will say even they do not understand your English. That will be the only difference which you will have. What has happened to you people? I do not know. So many rulings I cite, so many books I cite. Nobody is coming and telling me what you have cited is wrong. The book is not like that. And you are taking my words as gospel truths. Where is the challenge? Where is the spark in the argument? Where is the beauty of presentation? Well, in which case, every day I am again observing whether I missed something beauty in the argument. Let us see. Somebody has argued good in these video clips I am seeing, only for being disappointed again. Why you are not reading? That's my question. And this is Saraswata Loka. This is not cultivation. Nobody brings the book. Somehow he has brought the book. That's one appreciable. This is not that. This is 1982. 81. How many years have lapsed? How many years have lapsed after 81? Do you mean to say that for the first time in Dixit's court this question has arisen? Must have arisen before many courts. Where is the research, let alone search? Even research is not being done. Nobody brings the chit. Nobody brings the note. Nobody cites the law. Nobody refers to decisions. How various high courts in the country, there are such rules, how they have viewed this point. How many times I should go on telling this? I feel hurt because it is pinching you. It pinches me too. Unless quality people come from the bar, why freedom movement? All lawyers, best of the lawyers, C. Rajagopalachari, B.N. Rao, Dr. Ambedkar, Sir Alladi Krishna Swami Iyer, Gulabai Desai, Firoz Shah Mehta, all leading lawyers led the freedom movement because law gives that strength. I'll not say more than that anyway. Take note.
So, may I have a chance, my lord, to go through some judgments, my lord? Because today I am not with some...
We don't give that one. This is a war of wit.
Yes, my lord.
No opportunity will be given to the enemy to bring stronger weapons, best weapons, etc. No, it's not.
One sense, only one sense.
No, I heard you. What is there?
With regard to that retrospective effect,
yes,
I have to search.
Why did not you search all these days? Which client said not to search? Any client has told you, you should argue my matter without turning the pages of the statute book? You all people charge people. Poor people come here. You take money. You don't do justice. Suppose if I don't do justice after taking the salary, why you are not doing? I don't understand. Or you are not interested. Are not interested in my court. It's not like that. I inquired with my brother. So they also said the same thing. No, not much different, they said. But very few people argue wonderfully. I feel like listening to them. I never hesitate to bestow some orders because they come with preparation. They should not go empty-handed. You will come with full preparation next day. And call tomorrow.
But some more than 2 to 3 days.
Why? So that I can forget.
No. I will place all the matters in beginning.
Yeah. For further aid. Yes. 3 books I am giving you. Number 1, Maxwell on Interpretation of Statutes. Sutherland and Statutory Construction. Write down, you will forget those books. Crawford on construction. Crais on statutes, CRAIS, Crais on statutes. Our Indian version is JP Singh. There is Vipasarati, but anyway, JP Singh you can look into. All these comparative studies you should do. Then Vidya will come to you. Saraswati will not come to you that easily. She wants everybody to toil hard. Lakshmi may come by lottery. Saraswati, no library comes by lottery. You have to bring every book and keep in the shelf. Ordered money. Yes, read all these things and come back. DP Singh also mentions 3 judgments of the apex court. Yes. Next. Item 56. Reading nothing.
May I please, Your Lordship?
Yes. Are you fully prepared?
Yes, ma'am.
Because arguing again in
No, I'm fully prepared.
Yes.
My lord, the petitioner is a widow, my lord, and his application for appointment under Rehabilitation Assistance Scheme has been rejected by the opposite party on the ground. Yes, my lord. That has been rejected on the ground that the application has been filed in a belated stage, my lord, after 1 year and 9 months, my lord.
Whether there is a prescription of limitation in the law?
Yes, my lord.
Then what is the case we have? No case we have.
Yes, my lord, there is a relaxation clause is there.
Is there?
Yes, my lord.
Read that. Did you request for relaxation? In your application for compassionate appointment, did you seek for relaxation?
No, my lord. That was.
But it's their duty to look into whether there is a case for relaxation or not is your version. Do you understand what I am telling you?
Yes, my lord. They have rejected my application and I have filed this writ application, my lord.
The further employee died in harness which date?
My lord, he is died on 14/1/2018.
14/1/2018. What was he?
He was a assistant teacher in a UP school, man.
Oh. And you applied on which date?
I applied my lord on 10/11/2020.
10/11/2020.
Yes, ma'am.
What was the terminal benefits you got? Pension?
Yes, ma'am. All thing I got, my lord.
Full amount. Yes, how much money you have got?
My lord, that.
How many years of service he had put in?
Yes, more than 10 years, man.
10 years.
Yes.
What's the pension you are drawing?
Pension amount, my lord, I have.
So that you have to state, na? It is for the people for tiding over the difficulty arising out of death in harness. 53 Supreme Court. Death in harness. But death creates many problems. If he is a breadwinner, the family will become destitute. To overcome that, it is compassionate. It's not right. It's a privilege.
Well, the state government came for a modification, my lord, in 4th April 2025, where they have stated, my lord, I will take man's attention. In case of death of government employee occurred on or after commencement of the Odisha Civil Service Rehabilitation Assistant Amendment Rules 2016 and before commencement of the Odisha Civil Service Rehabilitation Assistant Rules 2020, the appointing authority shall ascertain the present financial distress of the family by calling for a report from the collector of the district in which the family ordinarily resides as to whether the family is in the financial distress as the provisions of Rule 8 of the Odisha Civil Service Rehabilitation Assistant Rules 1990.
But you are not disclosing what is the terminal benefits you received?
Yes.
What is the pension you are receiving? Suppose you are with pension, you can hold your body and soul together. No employment.
Yes, ma'am. That is a government also might clarify explanation for distress certificate prescribed under Clause C. The total annual family income from all sources, excluding family pension and temporary increase, must not exceed 1,91,000 for a family to be distress condition. So
1,91,000.
Yes, 1,91,000 per annum.
There it is.
So my total income is
16,000 rupees per month.
Yes.
So I am coming under my lord that.
They have given the notes or certificate.
Yeah, everything I have given my lord.
Where have you stated you have given the certificate?
My lord,
Which certificate?
my lord, my application for my lord annexure 2 phase 14.
Go to 2.
They have only rejected my application on the ground of delay, my lord.
You applied on 10/11/2020.
Yes, my lord. 10/11/2000.
And the application according to them ought to have been made when?
Within time limit of 13/1/19.
13/1/2019.
Yes, my lord.
That is 1 year.
Yes, my lord. Before that, the rule says, my lord.
Where is the clause which provides for condonation of delay?
Yes, my lord. I will take to my lord's attention to Rule 9, my lord.
Yes.
Condition of service. Sub-rule 6. Application for appointment under these rules shall be considered if it is received within 1 year from the date of death of the government servant.
Correct.
Yes. Then my lord, come to rule sub-rule 11 of rule 9. Notwithstanding the period of limitation prescribed in sub-rule 6, the delay in submission of the application for appointment under these rules may be condoned by the state government in concerned administrative department by an order to be effect that the applicant had sufficient cause for not submitting the application within such period.
But you have not shown any cause at all. Why there is delay? Have you explained it in your application?
In my read petition, my lord, paragraph.
Not read petition,
No,
application.
No, my lord.
It is almost like Section 5 of Limitation Act. How courts have said whether they should on their own should ascertain there was a condition for justifying the delay, etc. How courts have viewed that provision? How various brother judges have construed that rule?
My lord, I'll take my lord attention to judgment of our own High Court, my lord. But the relaxation clause has been explained, my lord.
Has been given benefit.
Yes, my lord.
That even when you did not ask for that.
No. See,
that question is not decided.
See, after this honorable court, my lords have directed to approve the state government, so they make they consider the relaxation clause.
Considerations they have never shown one single case where duly considered relief is granted to the employee, person, citizen. Consider and reject. What do you say, brother? There is a clause.
My lord, I had seen that, my lord, in the rule itself, 90 rule, it is there itself.
Correct.
But death was occurred during subsistence of 90 rule. Before 2020 rule came into force, my lord.
Correct.
What my friend says, everything is right. But he is to approach the government for condonation of delay, administrative department.
He
has not, instead of doing so, he has approached your lordship.
She is not some Tata Birla company. She is a widow.
My lord,
lost husband. She is in distress, finding for eking a means of livelihood.
My lord, that's why.
It is like it.
That's why, my lord, the rule is also very clear that my friend has submitted rule 11. My sub-rule 11 of rule 9.
Correct.
There is a provision for condonation of delay by
to exercise that power is my country. My
lord, unless she approaches them and thereafter, my lord,
she is so much intelligent. She will not come to the government seeking a job at all.
My lord, let me kindly have a look to rule 16 also.
16
of the the state government. I am pleased for reading that.
My question is, this is a socio-welfare beneficial provision.
I am obliged, my lord. That's it.
Slowly.
I am not coming on the way. I am just assisting your lordship. That the state government were satisfied that the operation of all or any provisions of these rules causes undue hardship in any particular case. It may dispense with or relax provisions so as to extent as it may consider necessary for dealing with this case in a just and equitable manner.
This is in addition to The sub-rule which he has read.
Yes, that is
So
right.
the policy of the state is to grant relief,
Exactly.
relaxation if necessary.
But
Government's policy.
in such cases shall be examined by the General Administration Department and orders of the Chief Minister shall be obtained. This is what the rule is.
That's what. That is in addition to that condonation.
Exactly.
Therefore, state wants to be kind to the people of kind.
Yes, its employees.
Because person is dead, he may be breadwinner. This family will be in distress. That is the right. The person worked for more than 10 years.
Yes.
Therefore,
Let's may direct them
to
exercise the powers conferred in Rule 9, Sub-Rule 11, read with Rule 16.
they will we have exercised and
No.
and therefore rejected. One more litigation. No. Because the person, now you have not taken any contention. See, there is one judgment by Justice M.N. Venkatachalaya, as his lordship then was, ILR 1986 it may be, where an appeal was filed with delay. The Honorable Judge said, the great Venkatachalaya from Karnataka,
Yes, my lord.
he said, you can't reject the appeal without giving an opportunity of hearing to the appellant to file application for condonation of delay.
Exactly.
Where it is
Reasonable
delayed.
opportunity of
Yes. You should tell him, your appeal is delayed. Do you have any explanation? File an application. If he does not file one, then appeal will meet its fate. It's a beautiful judgment. This is how justice has to be done, not just administration of law. Right. Please be seated. Petitioner widow, having suffered rejection of her application for compassionate appointment on the ground of said application being belated, is grieving before the writ court, contending that the husband employee died in harness on 14/1/2018, and therefore, though she ought to have applied for such appointment on 13/1/2019, the same ought to have been favored. Regard being had to the statutory policy as expressed in Rule 8, Rule 9,
Sub-Rule 6.
Sub-Rule 11.
6.
Sub-Rule 6, which provides for condonation of delay.
No. Sub-Rule 6 speaks that within 1 year he is to apply.
Therefore, it was Sub-Rule 9. 9.
Sub-Rule 6, it is there for specific
That is limitation.
Yes. Condonation is
Next paragraph.
11.
Learned counsel for the petitioner argues that the provisions providing for compassionate appointment or an exception to general recruitment rules and the construction of its provisions have to be animated with humanity and compassion. First of all, that being the position, the application could not have been negatived by a court order that it was belated, especially when the provision provides for condonation of delay, regard being materially had to hardship of the applicant, the breadwinner of the family having died in harness. First. Next. Learned AGA appearing for the no objections are filed, no counter filed.
No counter filed.
Appearing for the OPs resists the petition, contending that though there is a provision for condonation of delay, no prayer for such condonation was made in the subject application, nor there was available any material warranting the condonation. First off, no counter has been filed in this petition, pointing out as to why the condonation of delay was not made, nor indicating whether the applicant was put to notice of the said delay in making the application so that she could explain the circumstances, if any. Warranting exercise of power vested in under Rule 11 of Odisha Civil Service Rehabilitation Assistance Rules 1990. Just next paragraph. Having heard the learned counsel for the parties and having perused the appeal petition papers, this court is inclined to grant indulgence in the matter on the following, as under for the following reasons. A. The subject rules are founded on the idea of difficulty which the family of a government servant dying in harness would encounter in the game of life. First off, therefore, the provisions of such statutory policies as expressed in the form of rules have to be approached with sympathy and kindness, and not with Portia's knife in Merchant of Venice. First, the employee died in harness on 14/1/2018, as already mentioned above. Semicolon. There is no dispute that the applicant seeking compassionate appointment is his widow. Who had applied on 13/1/2019. Applied for such appointment on 10/11/2020, when the cutoff date was 13/1/2019 under 9(6), correct? Rule 9(6). 9(6). Semicolon. Ours is not an East India Company, nor a Mughal rule. Semicolon. Compassion is not alien to constitutionalism. Semicolon. All scriptures, whichever faith they may belong to, prescribe compassion, practice of compassion as a virtue. First off. such compassion has to animate decisions of the government and its officials when rules of the kind are being construed. First, that having not happened, there is error apparent on the face of the impugned order, warranting its invalidation. Next paragraph. Rule 10(9) provides for condonation of delay is beyond dispute. Whether for such condonation, the applicant whose family is in distress, the breadwinner having gone with the wind, has to explain, or our model government, constitutionally ordained, has to ascertain the circumstances which otherwise would merit condonation of delay, is the question. First off, obviously, the model government has to conduct itself tall with the have-nots, like the petitioner hearing, who is fighting for the job to eke out livelihood. First off, denying job only on the ground of delay is too harsh to be sustained. First off, John Rawls, in his Justice as Fairness, advocates that all model governments should exercise their functions with fairness to the citizens. And that fairness is militantly lacking in this case. First off, there is a next paragraph. The vehement submission of learned DGA that rule 9(9)? Yes. 8(9), huh?
9(11).
9(11), which provides for condonation of delay, is a pari materia with Section 5 of Limitation Act 1963. And unless an application is made for such condonation, yes, the government will not have occasion to exercise the power of condonation, is bit difficult to countenance. First, in considering the idea of pari materia, it is not the text and language of the provision which is material, but the subject matter and policy content thereof are. First, in cases where the compassionate appointment is sought for belatedly, the government has to ascertain from the applicant as to whether there are circumstances which resulted in brooking of delay, whether the prayer for condonation of delay is formally made or not. First of all, a construction of the statute to the contra would defeat the very object of such provisions, to say the least, and Red Court will not permit it to happen. First of all, next paragraph. In the above circumstances, there's one more aspect. Learned AGA submitted that the power to condone delay is with the authority, and therefore matter may be remanded for consideration afresh. But this argument does not impress, in as much as it has the potential of breeding one more litigation to the existing law. First off, a citizen cannot be denied relief by quoting some jurisprudential theories. Second, the aggrieved citizens knock at the doors of the court for justice and not for theories of law. First off, no counter having been filed, no other ground than delay is stated in the impugned order. First, the apex court in Mohinder Singh Gill versus Chief Election Commissioner, 1978, AR 1978 C 851, said that the validity of an order passed by a statutory authority has to be adjudged on the basis of reasons given in itself and not supplied dehors. First off, if delay ground goes, the application for compassionate appointment has to be favored, and appointment order has to be issued to the applicant, at least belatedly now, that is after 13 years, more than first half year, reckoned from the date of death of the breadwinner of the family. No, it was 2018.
18, my lord, died.
That will not be.
14/1, 2018.
How many years? It will be about that. 7 years. More than 7 years. First, next paragraph. In the above circumstances, this writ petition is allowed. Semicolon. The writ of certiorari issues, quashing the office letter bearing number 2672, dated 12/4/2024, issued by whom?
Issued by the district education officer.
OP number?
My lord, is OP number 3.
OP number 3 at Annexure 1. Semicolon. The writ of mandamus issues to the jurisdictional OPs, which would obviously include OP number 3, to allow the application for compassionate appointment and grant compassionate appointment to the petitioner within a period of record from this day. First off, next paragraph. Delay or default shall be viewed very seriously in the next level of litigation. If petitioner is driven to launch one Full stop. It is open to solicit any information or document from the side of petitioner as are required for accomplishing the mandate of this judgment. Courts reluctantly made easy. Web copy of the judgment to be acted upon without insisting upon production of certified copy. Write it that way in all judgments. Okay. Can I return this book tomorrow?
Yes, yes, Professor.
So that it becomes handy. Tomorrow we'll just point out, assign your colleague so that we will collect the book back. All right? Stop. A little linguistic model will undergo change because I have to refer to some other judgments.
Yes, madam.
Just refer to Justice Amendment judgment. And IL, can anybody find out that ILR 1986 Justice M.N. Venkatachala or Venkatachalaya? There are two judgments. One is by Chalaya, another is Venkatachala. Both were great judges of Karnataka High Court and later Supreme Court also. ILR 1986 Karnataka. One is by Justice Venkatachala and Rajashekhara Murthy. Another is Justice Venkatachalaya. Other judge I do not remember. Two judgments are there. Just any youngsters can locate those judgments and leave it with my court office.
My Lord, with due apology,
yes.
Lordship may kindly check the provisions of the rules.
Yes.
While
once again.
Yes. Provisions of rules, my Lord, as mentioned in some places, my Lord, Lordship may kindly verify the rule which your Lordship have quoted, Rule 9, 6, 11, etc.
That I have to verify. Just which is condonation of delay, which is limitation. Rule 9.6 is limitation.
Condonation is 11.
9.11 is condonation. Okay. Thank you.
Item 57.
May I please, Your Lordship? I would like to seek for some time to prepare with the case. The pleadings have been completed. We need some time to.
When pleadings were completed?
My Lord, rejoinder was.
Which year matter?
My Lord, this is 24.
24.
My Lord, rejoinder.
Your objection for giving that?
I'm for the university. I have filed my counter affidavit.
Oh, filed it.
They have filed a rejoinder. A copy may be served on us. So that
I'll serve him.
Call in second week of October 2025 at the request of arguing counsel for petitioner. Next.
Bless you, Lord.
Item 58.
Ha.
58, my Lord.
Yes.
Notice on OP 10 and 13 is not sufficient.
10 and 13 to be notice to be taken.
To be fresh steps to be taken. And another thing.
10 and 13.
My Lord. That is the note.
10, only 10, my Lord.
Only 10. 13 is already taken. Only 10.
Well, office note is 10.
No, that is X13. OP10 is at flag X13. The notice issued to OP10 is at flag X13.
No, above that. Above that, tracking report of registered post notice issued to OP number 13.
Anyway, you take whatever unserved upon steps to be taken for serving unserved OPs. Whichever. You go to the registry, inquire, and find out to whom it should be.
It is there in the note. I will text.
Number 1 is over. Then.
And that one flagged D, a counter affidavit by OP 15. That copy I have not received.
Malat, I will
share a copy.
Yes, Malat, I will.
We also because we can for
page.
Counter copy of counter to be served on all the counsel appearing for all the parties.
Yes.
Yes.
Next.
And that is there for compliance of the office report matter. Then
any other complaints?
Tracking
nothing.
Others are sufficient.
In that report item, no such 13 is there.
Yes, 13 and 10. 13 is a
item returned, addressee left without instruction. Therefore, he has to take care of this.
13 and 10, I will.
No, not record, my Lord. 11, 12, 13, I am appearing.
11, 12, 13, you are appearing?
Yes, Your Lordship. 11.
So, let counsel Shri
Asutosh Mishra.
Mishra appears for 11, 12, 13.
My lord.
So steps to be taken only in respect of 10.
13.
Yeah, fresh steps. Okay. Requisite within 3 days.
We have filed our counter.
You have filed. Okay. Next.
My lord, interim order there, it should continue.
Interim order to continue till next date of hearing.
Item 59.
59.
May I please?
Yes.
My case stands on a very small pedestal. But here I have challenged the order passed by the District Education Officer Kyonjhar under Annexure 9. But the dispute is relating to date of birth.
Date of birth.
Your Lordship, may kindly see my service book. When my service book was opened, that is at Annexure, Your Lordship, may kindly see Annexure 7, page 23.
How that question crops up? Retirement?
No, not retirement. My lord, the district education officer took up my date of birth from my admission register made in the high school. And he found that in my admission register, my date of birth was recorded as 56, that is 5/3/1956.
5/3/1956.
In my admission register, in class 8.
Class 8?
In class 8, in the admission register, my date of birth was recorded as 5/3/1956. By that time, I was a minor. Subsequently, at the instance of my father, that was changed and it was made 5/3/1960.
1960?
5/3/1960. And
that was reflected in which document?
My lord, that was reflected in my HSC certificate, board certificate.
Original board certificate?
Original board certificate. And nobody questioned the same. And in my service book also, my date of birth was recorded as 5/3/1960.
That service books generally follow HSC.
Yes, HSC. Your Lordship, may kindly see page 29, Annexure 7, the entry made in the service book. Annexure 7 at page 29.
5/3/1960.
5/3/1960.
Correct.
Then, Your Lordship, may kindly see my date of birth entered in the HSC certificate, that is at Annexure 6 at page 27. Page 27. Board certificate. 5th March 1960. And this was also entered.
March 1960. But not June 60.
No. That is 5/3/1960. Sorry, I'm 5/3/1960, not June.
But in the service certificate?
In the service certificate, that is 5/3/1960. 5/3/1960. You will also may kindly see Annexure 7 again.
5/3 only?
5/3, not 5/9.
Now he has resigned, otherwise also.
My lord,
yes.
The district education officer forced me to retire from service. My lord, that is on 17 by virtue of order dated 17/11/2017 with effect from 31/3/2014.
3 years you worked?
3 years I have worked, but I was compelled to retire from service with effect from 31/3/2014 by treating my date of birth as 5/3/1956. And the reason district education officer is that in my admission register in class 8 of that very high school, the date of birth was recorded as 5/3/1956.
You filed the WP when?
My lord, initially I filed original application before the tribunal
Transferred to.
Yes, that is OA number 3373C of 2017. And the learned tribunal also passed an interim order. My lord, may I kindly see that?
I believe you.
My lord, interim order was passed that my retirement will be subject to result of the OA.
So you
After abolition of the tribunal,
to transfer.
It was transferred to this honorable court. And in this honorable court, I filed an IA. No, my lord, IA was filed before the tribunal and it was transferred to this honorable court. And for amendment, because I wanted to incorporate the service book. Then this honorable court granted me liberty that you file a fresh writ petition incorporating the service book. Then I filed a fresh writ petition
When
here.
that WP was disposed of?
My lord, that WPC, yes, that I have quoted.
OA number?
The first OA is OA number 3373C of 2017. 3373C of 2017. Your lordship will get the reference at Annexure 4.
2017.
3373C of 2017.
3373 of 2000.
C, within bracket C. Because it was filed in Cuttack. Odisha Administrative Tribunal, Cuttack bench, Cuttack.
That there are two benches.
Yes.
One is in Cuttack,
Principal
another
bench
is
in Bhubaneswar and
so it will be B and C.
Yes.
That way. The order challenged was what?
My lord, I challenged the order before the tribunal that was passed by the District Education Officer Keonjhar when I was forced to retire from service by virtue of order dated 17/11/2017. That is under Annexure 3.
Then you worked till 2017.
I worked till 17/11/2017.
Prospectively retired.
No, my lord. I would have retired from service on 31/3/2018 in normal course.
31/3/2000?
31/3, 31st March 2018. Had my date.
He retired you on which date?
My lord, he retired me from a retrospective date that is with effect from 31/3/2014, but order was passed on 17/11/2017. So I worked till 2017.
And you drew salary?
My lord,
everything.
No. My lord, salary for certain period that was also not paid to me.
What period it was not?
That period, my lord.
Whatever period you have worked, that you will get.
Yes.
Because that is the date of Article 23.
Yes, absolutely correct. Now, my lord, I have brought a decision. Identical matter was disposed of by a coordinate bench of this honorable court. Holding therein that the date of birth entered in HSC certificate. That is to be acted upon. Lordship, may kindly see that.
Why that occasion arose as to doubting the authenticity of your date of birth? What are your brothers doing?
My lord,
how many brothers and sisters you have?
My lord, brothers, I don't have that information.
That information you get.
Yes, I will get.
Petitioner to furnish the full details of brothers and sisters along with the particulars of their dates of birth as reflected in the school records.
Yes.
Failing which a heavy adverse inference may be drawn against the petitioner.
Yes. Your lordship may grant me some time.
I will give time. How much time you want?
2 weeks.
2 weeks. Within 2 weeks. All after 2 weeks, immediately after 2 weeks. That will tell the truth.
Yes.
But whatever period you have worked, on that you cannot be denied salary.
Yes.
Because beggar, the word beggar is employed in Article 20.
And if he has discharged his duties, he is entitled to get his salary. Yes.
Item 60.
May I please, Your Lordship?
Yes.
Well, it's a simple case, my lord. One requirement was put, my lord. One qualification was put in respect of appointment of Hindi teacher. That was the subject matter challenge.
You were appointed as teacher.
No, it's
You were not.
recruitment process.
It's a recruitment process.
Yes. They have indicated, my lord, earlier. The requirement was one of the following training qualifications. That is Hindi Shiksha Prarangat and Kendriya Hindi Sangathan Agra, BHED, a course prescribed by NCTE from recognized university institution, BEd in Hindi, a course prescribed by NCTE from Dakhin Bharat Hindi Prachar Sabha, Madras. These are the three training qualifications were earlier there, since 2024. Even government may not prescribe that resolution in 2020 also, conforming to this. After 20, one addendum was issued, putting one qualification.
One more qualification.
One more qualification. According to me, that should not have been the training qualification. They have said, clause 4, BEd from NCTE recognized institution. So general BEd also made that given that opportunity to participate. When these three were there, one of the following qualifications, training qualifications, Hindi Shiksha Program from Kendriya Hindi Sangathan Agra, BHED, a course prescribed by NCTE from a recognized university institution.
What is that BHED?
That is bachelor's in Hindi.
Okay.
Then Hindi education.
Hindi education.
Then BEd Hindi course in NCTE, BEd in Hindi, prescribed. Subsequently, BEd from recognized institution, general BEd is also made up eligible to participate.
How you are agreed with?
I must indicate to you, one of the writ application was earlier filed against this, but that was turned down, my lord, saying that since you have participated in the selection process with this qualification being introduced, so writ is not meant, that rejected the writ application on the ground that with an observation that government has the policy is the policy maker, has the authority to do that. Only, my lord, if you also look at the 3 and the 4, 4 is not.
How you are agreed by that?
Agreed, my lord, because the zone of consideration is higher.
That makes no sense.
Only
that for the employer to prescribe.
Exactly.
Employer wants to choose best of the mangoes from the market. If you are not best mango, some bad fellow will buy you.
this Hindi, your lordship is correct. But this Hindi is guided by NCT regulation.
It's employer's prerogative.
The NCT has never prescribed this.
Very well. Why NCT should prescribe this? Employer wants to prescribe that. Employer's prerogative.
No,
unless employer prescribe. This is what Samaraditya Pal writes in his services. Mr. Swain might have seen that judgment. Samaraditya Pal, Justice Rama Joyce in services under the state. They are of the opinion it is the prerogative of the employer to prescribe the qualifications subject to exceptions. It cannot be highly arbitrary. You cannot say that you have to bring 1 gram of earth, the earth from the moon. They cannot prescribe. That will be an impossibility. If such conditions are prescribed, writ courts will interfere. Otherwise, we do not know what is the requirement of mind. We want the best teachers. More the qualification. Assumption is more better the candidate would be.
Only one thing, because it's a specific subject Hindi. And NCT has already prescribed.
You mean to say government does not understand all these things? Only court will understand. And you alone will understand.
No, the government has done it in 2020 and 2023.
Now it wants this one. Earlier, only LLB was sufficient for so many positions. Not even LLB. Mukhtiar examination was there. That was sufficient. Advocate clerks were made munsifs. That was there. Now we have progressed. We are going for the higher value.
But doing that,
all benches. Will you go to some MBBS doctor? Suppose there is ailment. You will not choose just MBBS doctor, but you will choose best doctors having good qualification. How will you assess? What is the qualification of this physician? This is good. always pursuit of excellence. In American constitutions, there are judgments. The pursuit of excellence itself is a fundamental right. That's what. You not dictate to the employer what he should have, what he should not have. Yourself being a candidate in the parade, can you dictate?
No, the only thing, Madam, I put your lordship's notice, Madam, same government for different department.
It's left to the visit.
They have done it on the initiative qualification.
It's a prerogative, unless you, therefore I told you, it may be wrong. Every wrong is not redressable. Certain wrongs remain with the authorities because they are employers' prerogatives. Employers' prerogative. There's any standard book.
No, that is the law, and I don't dispute that. Even
the short grievance of the petitioner is as to prescription of additional special qualification in addition to the earlier 3 existing
training qualifications.
Training qualification for recruitment in question. All through, only 3 qualifications were there, and therefore there is no reason or rhyme for adding one more. That would enhance the level of competition to the prejudice of his client. First of all.
Lordship, just indicate that clause. BED from recognize that additional qualification.
Yes, I look into it. Yes, you appear for the...
Yes, my lord, I am appearing for the interveners.
You give your fees back to me. Learned panel counsel appearing for the OPs. You are for OPs?
I am for an intervener who has that qualification which he challenges.
Okay. Who appears for the OPs? Learned AGA appearing for the OPs opposes the petition contending that what additional qualification should be prescribed for the prospective employee is a matter of prerogative of the employer, and a candidate in the fray of employment recruitment cannot dictate terms to the prospective employer. First of all, I agree with this. First of all, Samaraditya Paul on law relating to service. Justice Rama Joyce in services under the state echo the same. Just those paragraphs you have to just bring that book and this one. Do anybody have the Rama Joyce book? I'm not getting it. In fact, I have in my Bangalore. I did not bring that book.
Rama Joyce is available in the Judges Library.
Judges Library? Yes, sir. 84 edition, old edition?
Yes, yes.
But next one, in the above circumstances, petition being devoid of credits is liable to be and accordingly dismissed. Courts having been made is public. Meet tomorrow? Yeah.
Item number 69 that transfers compulsory TC was granted.
Disposed of.
Tomorrow.
Urgency. Students matter. Item 70 is also student matter. There is for strictness or even Friday it was there. What is the delay? What the consequence of delay? Consequence not delay. That is the re-evaluation of mark. My friend has appeared, Mr. Patnaik. Only as he is suggested, because there is a guideline of the CBSE day after tomorrow. Item 70.